Good morning, Mr. Pikelson.
Good morning, Your Honor.
Okay, you're here with Mr. Williams.
I am, Your Honor.
Mr. Williams, can you hear us?
Yes, ma'am.
On the record in the matter of the people of the state of Michigan versus Calvin Williams and file number 21-03263 apply. Counsel appearance, please.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson appearing on behalf of Mr. Williams this morning.
Today's the date that's set for a sentencing. I do have a sentence report and recommendation. And Mr. Ferguson, did you get a copy of that?
I did, Your Honor, and Mr. Williams and I had a chance to go over it. We do not have any corrections to the report, Your Honor.
Okay, I also have 3 bond violations that need to be addressed.
All right.
I have a GPS violation report alleging that Mr. Williams entered the exclusion zone at approximately 8:55 and exited the zone at 8:58 p.m. The GPS company JFD monitoring attempted to make contact with Mr. Williams, but he didn't answer their call. I have another alleged violation. That he entered the exclusion zone on February 5th at approximately 6:24 p.m. and exited the zone at approximately 6:34 p.m. Then there's another alleged violation. That he entered the exclusion zone on January 13, 2022 at approximately 10:45 in the morning and exited at approximately 10:46.
Judge, may I have a brief breakout room to discuss these allegations with Mr. Williams?
Yeah, I'm just reviewing the maps on these. I mean, the one that he was in there, the one that he was in the exclusion zone for 1 minute, it's not the most concerning, obviously. There
Right.
is one, he was in the exclusion zone for at least 10 minutes. So we'll go off the record. I'll let you speak to him privately. Okay, Mr. Cornish, you're here with Mr. Blevins.
Yes, Your Honor, for a plea.
Yes. Sorry, what?
Okay, who do we have in the jail?
This is Mr. Javon Hopkins, Your Honor.
Okay, is this your client, Mr. Hopkins? Okay, Mr. Austin, you can come forward. I
Mr.
can't hear what he's saying.
Mr. Hopkins, if you talk through here, she can hear you better, okay?
I said, Your Honor, I wanted an in-person line before I even stepped into the courtroom. I told my lawyer that yesterday, I'm cooperative, I'm fully cooperative, I'm not. I told her that I wanted a lineup before I even go in
Mr.
court.
Hopkins, if you're talking to the court, I can't understand anything you're saying. You gotta come closer, sir.
I wanted an in-person lineup before I come into the courtroom.
He wants an in-person.
Before anything, I told my lawyer that yesterday.
Your Honor.
I don't want to get an in-person lineup, and I want a new lawyer. He's not representing me again. I don't have a discovery packet, anything.
Okay, I think your attorney is aware of what your requests are. You're being represented by counsel, so we'll go on the record and call the case, and he can make any motions he believes is necessary. Okay, Mr. Hopkins?
I would like to request, please.
Mr. Hopkins, I don't want to have to mute the device, but you can't just be blurting out in my courtroom, okay?
Yes, I understand.
Okay, so I need you to be quiet until I ask you, do you have any questions, okay?
I can't hear you.
I can't hear what he's saying.
They just closed the door, Your Honor. I couldn't. Sorry.
Okay, what, is there a particular reason why he's calling in from a cell?
We asked Mr. Hopkins to go into the arraignment room and explain to him, Your Honor, that his lawyer would be in there to meet with him, and he refused to leave and walk into the breakout room, or refused to walk into the arraignment room at all.
Sounds good. We're on the record in the matter of the people of the state of Michigan versus Javon Michael Hopkins, file number 22-00214. Council appearance.
Good morning, Your Honor. Amy Lacey, standing in for the attorney of record, Randy Thurman, for the people.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Javon Hopkins, who appears with us remotely from the LPD lockup.
Thank you. And today was the date that was set for preliminary examination. My understanding is that there's a request for an adjournment for additional discovery. Is that accurate?
That is partially correct, Your Honor. There is a request for an adjournment. It's not because we're waiting on additional discovery. We just received a bunch of additional discovery. Apparently, there were some reports missing as it pertained to this case. They were over 30 pages. We did not receive those until Wednesday afternoon, when the prosecutor's office discovered that we did not have them. They got them to us as quickly as they could once they did discover that. Obviously, I have not had a chance to get Mr. Hopkins a copy of those so that he could review them. I did meet and speak with him yesterday and review the contents of that. Obviously, he would like his opportunity to review them so we can have a better, more thorough discussion on that. And apparently he tells me that he has not received the initial discovery that I sent him. There has been kind of an ongoing issue sometimes when we send correspondence to the jail, issues with them either not receiving it or taking an inordinate amount of time to receive it. In addition to that, Your Honor, I have one of my scheduled visits between the probable cause conference and the preliminary examination. I was not able to have the jail inform me that Mr. Hopkins was having a medical issue, so obviously that interfered with some meeting time that I would need to have with Mr. Hopkins, because obviously these are very serious charges and there's a lot of it to review. So we would be requesting an adjournment of the preliminary examination for that reason, and as well as Mr. Hopkins informed me yesterday he wished to make a request for a memorial lineup in addition to that.
I had to mute the detention. Can you unmute for me, please?
Can you hear us, ma'am?
I can, thank you. Mr. Hopkins, Mr. Hopkins, can you hear me?
Not really.
Mr. Hopkins, can you hear me?
Yeah.
Okay, did you hear the statements that was made by your attorney?
I couldn't heard it a little bit, but he didn't say anything about my in-person lineup that I asked for.
He did. Actually, he did mention it. So that's why I'm asking you, did you hear what he said?
I'm sorry, I didn't hear
Okay, okay. So because he just recently received a certain amount of discovery that he still needs to review with you. There's also been some issues with you receiving some of the discovery that he's already sent to you. And he mentioned also your request for a pictorial lineup. There is a request to adjourn the 21-day timeline of your examination. So you were arraigned on this matter back on January 25th, 2022. You have the constitutional right to have a preliminary examination within 21 days of that date. But due to the additional discovery plus the potential for a pictorial lineup that you're requesting, are you willing to waive your 21-day timeline so that we can set it for a new date so that those things can be reviewed, and if a pictorial lineup is going to be formally requested, that one can be performed? Are you willing to waive the timeline, sir?
Your Honor, I don't need the discovery. I did not adjourn it for the discovery. I just want the lineup. That's it, the in-person lineup. That's why, that's it.
Okay, thank you. The court's gonna find good cause to waive the 21-day timeline, and we'll set it for a new date. Does March 11th work?
Your Honor, I'm standing in for the attorney of record who actually will be handling the exam, and he's on his way, but I don't know what his schedule is.
Okay, do you know how long it's gonna take for him to get here?
He said he would just be here in 2 minutes, but that was 3 minutes ago.
Okay, we'll set it for March 11th now. If that doesn't work, when he gets here, we can find a new date that works for both him and Mr. Austin.
Okay.
At 9:30. At 9:30. Any additional matters for the record?
Just one correction I wanted to make, Your Honor, is that Mr. Hopkins is requesting a pictorial or in-person lineup.
Oh, he's requesting an in-person lineup.
Yes.
Okay, well, you can submit that formal request. I'll note that in the file, but that's between you and the prosecutor.
Understood, Your Honor. I just wanted to clarify that for the record. Thank you.
Thank you.
With that, I have
Are
nothing
you
further.
handling Hopkins?
I am, Your Honor. Thank you.
Okay.
Randall Berman on behalf of the people.
Thank you.
Mr. Austin's free to contact me with regard to a lineup. What I can tell the court is the information that I have and have seen is that the person involved, Mr. Hopkins, is wearing a mask, so I don't know that a lineup really would help. But we're free to discuss that. And
Okay.
as far as his request for an adjournment, I have no objection.
Well, the court's found good cause based on the request to adjourn it. We want to know if March 11th worked for you or if you needed another date.
That'd be fine, Judge. Thank you.
They were set it for March 11th at 9:30. We're all set with Mr. Hopkins. Thank you.
Thank you, ma'am.
What's the date?
Thank you, Judge.
Thank you.
Thanks, Judge. Sorry about that.
No problem.
Bad. Yeah.
On the record in the matter of the people of the state of Michigan versus Leroy Blevins. The file number is 22-000017 FY council appearance.
Morning, Your Honor, Andrea Lacey appearing on behalf of the people.
Good morning, Your Honor. May it please the court, Assistant Public Defender Steve Cornish on behalf of Mr. Blevins, who's in the court and standing to my right.
Thank you. Today's the date that is set for a preliminary examination. However, my understanding is there is going to be a plea. Is that correct?
Yes, Your Honor.
Can the prosecutor state the offer on the record?
Yes, Your Honor. The offer. Give me one second here. I'll make sure that I get it. And the offer is for Mr. Blevins to plead guilty to an added count 2 of child abuse fourth in violation of MCL 750136B7-8. That is a misdemeanor punishable by 1 to 5, 1 year or probation for up to 5 years. I apologize. We will Killebrew to no upfront jail with the understanding that the defendant will serve a term of probation. We are recommending 2 years, but we do understand that the actual time frame is up to you. The defendant is to participate in anger management classes, and he must undergo mental health and substance abuse evaluations and follow all recommended treatments.
I need a plea sheet to complete with that offer on it. Okay, Mr. Cornish, is that the offer that was extended to your client?
Yes, Your Honor.
Okay. Mr. Blevins, you understand the offer that's been extended to you?
Yes, Your Honor.
You wish to accept that offer today?
Yes, Your Honor.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
You can put your hand down. Mr. Blevins, you have the right to have a jury trial in this matter. At the time of jury trial, you have the right to have the prosecution bring sufficient evidence to prove each element of the charge against you, and they have to prove each element beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You also, at the time of trial, have the right to remain silent, not have silence be used against you. You have the right to cross-examine or question any other witnesses that they intend to call against you. And you also have the right to call your own witnesses or present any evidence you believe would further a defense you believe you have to the charge. Do you understand that?
Yes, Your Honor.
In order to plead guilty, you would have to give up all of those rights. You understand that, sir? I have an advice of rights and plea information sheet. Is that your signature?
Yes, Your Honor.
Can I put today's date on this?
Yes, Your Honor.
Okay, did you read this document, sir?
Yes, Your Honor.
You understand all the rights listed here?
Yes, Your Honor.
Do you have any questions about any of these rights?
No, Your Honor.
Are you pleading guilty because someone's forcing you to waive your rights and plead guilty?
No, Your Honor.
Is anybody making any promises to you to get you to waive your rights and plead guilty? Are you currently on probation or parole?
No, Your Honor.
You understand that a criminal conviction of this type could require you to report that you have a criminal conviction on a future job application, or you may have to report it to your current job. Do you understand that?
What's that, Your Honor?
You may have to report a criminal conviction on your future job applications or to your current employer.
Okay.
Do you understand that?
Yes, Your Honor.
Also, with the guilty plea, it could impact any immigration status that you may be seeking. You understand that?
Yes, Your Honor.
You still want to waive your rights here today?
Yes, Your Honor.
There's a Killebrew agreement, so that's an agreement about your sentencing between you and the prosecutor. I'm not a party to that agreement. So at the time of your sentencing, if I'm going to deviate from that and let's say sentence you to a term of jail time, I'll give you an opportunity then to withdraw your plea, okay?
Yes, Your Honor.
Okay. Are you pleading guilty to this charge because you believe you're guilty?
Yes, Your Honor.
As to the added count 2 of child abuse in the fourth degree, how do you plead?
Yes.
Can I have a factual basis?
Yes, Your Honor. Mr. Blevins, on or about December 31st of 2021, you're at or near the location of 5525 K North, KAYNORTH, number 8, City of Lansing, County of Hingham, State of Michigan.
Yes, Your Honor. Yes, Steve.
Thank you. And at that time, did you come into contact with Caleb Crawford?
Yes, Steve.
And that is your grandson,
Yes, Steve.
someone who you had either care or custody
Yes.
or control of.
Yes, Steve.
Okay. And during a argument with the child, you grabbed him about the head, is that correct?
Yes, yes, Steve.
And while not required, there was a little scratch by his eye, is that correct?
Yes, Steve.
And the child suffers from a medical condition that makes it extraordinarily dangerous to touch his head, is that correct?
Yes.
which would pose an unreasonable risk of harm to the child. Is that correct?
Yes.
And he is under the age of 18. Child.
Yes.
Thank you.
Any questions from the prosecutor?
No, Your Honor, the people are satisfied.
Sir, can you put your mask up above your nose? Thank you. Court is satisfied with the factual basis of accept your plea. Find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. The sentencing date is going to be April 14, 2022 at 8:30 in the morning. Prior to sentencing, sir, you're going to have a meeting with probation so they can provide the court with the pre-sentence report and recommendation. You need to go down to probation as soon as you leave this courtroom today, okay?
And where's that at?
You're on the 5th floor. Mr. Bigelow.
I'll walk him down. Your Honor.
Oh, okay, your attorney will show you where they are, and they'll get you all set up for your pre-sentence report. There'll be paperwork that you need to complete. They'll also schedule an interview date for you to meet with them. You need to make sure you follow up with all of those appointment dates, okay?
Yes, sir.
You do not want to come here on April 14th and not have completed your responsibility to make sure that the pre-sentence report was done, okay?
Yes, sir.
Do you have any questions for the court at this time?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing for the defense, Your Honor. Thank you.
Nothing for the people, Your Honor.
Thank you. You're all set for now, Mr. Blevins. Thank you.
Yes, sir.
They're all in order, but if you want it. Okay, we ready on Mr. Williams?
Yes, Your Honor.
Back on the record in the matter of the people of the state of Michigan versus Calvin Williams, file number 21-03263. Mr. Feigelson, did you have a chance to speak with your client about the alleged PA 53 violation?
I did, Your Honor, and obviously the court indicated the lack of concern with the 1 minute. Those issues where he was on a bus that went into the zone, Your Honor, with the one that he was in the zone for 10 minutes. He was helping a friend drop some furniture off at somebody's place in that zone. He didn't go anywhere near where the alleged victims live. Once he found out he was in the zone, he had to walk. And as he was walking out of the zone, the tether kept going off. That's the reason it took 10 minutes, Your Honor. So that's what happened here.
Oh, thank you. Okay, and back to the sentencing, I'm going to dismiss the PA 53 violation based on that explanation. As to the sentencing or the pre-sentence report, you said there's no additions.
That's correct, Your Honor.
Okay. Okay, did you want to make allocution?
I did, Your Honor. A couple things to point out. Obviously, Mr. Williams moved up here for employment, Your Honor. That employment didn't work out as well as he had hoped. He is originally from Georgia, from the Atlanta area, Your Honor. He has limited connections up here, but he is willing to stay up here and do the things necessary to complete probation despite his previous history, Your Honor. We did discuss all the different options, and he is willing to do probation. So we would ask that he be given an opportunity to be on probation and do the things necessary to complete it. Obviously, he can go back to Georgia, but they're not going to likely to transfer probation out of misdemeanor, but he is willing to stay up here and do the things necessary to help him get through whatever is going on and that's causing these issues, Your Honor. Thank you.
Yeah.
This has got to be the longest criminal history I've ever reviewed. Why would I put him on probation? This kind of criminal history clearly indicates a disregard for any law. They could care less about a law or any rules that the court could tell him to abide by while on a probationary term. He's not going to be compliant. Mr. Williams, I'll allow you an opportunity to address that.
Okay, can you hear me?
I can hear you.
Yes, ma'am. What was that question again, ma'am?
I said this has got to be the longest criminal history that I've ever had to review. And your attorney is requesting that I put you on probation, but why would I do that if the likelihood of your success or rehabilitation is not gonna happen? You're just gonna violate.
No, ma'am. I'm gonna do the very best I can, ma'am. I know I had some issues in the past, ma'am, but I truly believe that I can change and will change. Trying to seek employment. I have orientation next week with General Motors. I found we got my living arrangements all set up here, ma'am. If given the chance, ma'am, I would not let you down, let myself down, or my family down, ma'am. I do apologize for my past behavior, but I do feel that I can succeed on this probation, ma'am. And I'm home away from home, so I'm not around that same crowd, ma'am.
Right. I don't dispute that you have what it takes to be successful,
Yes, ma'am.
as it requires to the ability. It's just a decision that you need to make. That you're
Yes,
not
ma'am.
going to continuously engage in this type of behavior. I mean, this is a career of involvement in the criminal justice system. So you're going to need to show me or tell me what you're doing or what you've done that makes me feel like you're in a different situation. You're not employed. You say you moved here for employment?
Yes, ma'am.
Where was that?
I came up in with a traveling logistics team on working on behalf of Myers, ma'am. And the assignment had ended, ma'am, and I ended up missing my flight. So I ended up staying up here, met a lady, the victim, and things didn't work out, ma'am. But like I said, I have orientation next week with General Motors, and I'm trying to seek employment and just put this behind me and just try to be a pillar of the community, ma'am.
Okay, you say you have orientation with General Motors next week. What are you going to be doing there?
Assembly, ma'am.
I'm gonna be very honest, sir. I'm skeptical, but I'm gonna give you an opportunity only because you have a job lined up of what would be a rather good job for you. And if you decide that you're going to put your energy into something productive, maybe you'll stay out of trouble.
Yes, ma'am.
So I'm going to adopt, well, I'm going to go against the recommendation because the recommendation is not to put you on probation. I will put you on a term of 9 months probation. While on probation, you're ordered to maintain employment. Okay. While on probation, sir, there's a $30 per month oversight fee that you're going to be responsible for.
Yes, ma'am.
You're not to have any contact directly or indirectly with the victim or victims while while on probation.
Yes, ma'am.
You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use or possess alcohol, marijuana, or controlled substance unless you have a valid prescription. You're gonna be submitting to random preliminary breath tests and or urinalysis, and you're responsible for the fee to do that, okay?
Yes, ma'am.
Not to be at any bars or nightclubs while you're on probation. Do you have any questions about that at this time, sir?
No, ma'am.
I'm gonna order that you may obtain and maintain your employment while you're on probation. Participate in any other program as recommended by probation, okay?
Yes, ma'am.
Do you have any questions about that, sir?
No, ma'am.
I don't see that there was. Any restitution sought. So as to fines and costs, there's a $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost that will be assessed. I'm going to waive any discretionary fines and costs. Nine months of probation at $30 per month will amount to $270. But your total with the fines and costs will be $395. You'll be making monthly payments on that, okay, sir?
Yes, ma'am.
Do you have any questions about the fines and costs?
No, ma'am.
Mr. Williams, don't let me down because I'm not gonna go lenient on you if you let me down.
Yes, ma'am. I understand. I'm not.
You got a good opportunity here at General Motors. Don't squander it, okay?
Yes, ma'am. Yes, ma'am.
Okay. Any additional matters for the record?
No, Your Honor, thank you.
Thank you. Good luck, Mr. Williams.
Yes, ma'am. Thank you, Your Honor.
Have a good day, Your Honor. Have a good weekend, Mr. Williams. Take care.
Yes, sir. You too. What do we do about the teller?
Your Honor, he has a tether placed on. Is that gonna stay on, or I know that was a condition of bond?
We need to go and have that tether removed.
Thank you, Your Honor.
Yes, ma'am. Thank you. Thank you, sir.
Yep.
Mhm. Have a good day.
Have a good day, Your Honor.
What?
Have a good one. Okay. This is your client, Mr. Nickel.
Yes.
We're on the record in the matter of the people of the state of Michigan versus Christina Bryan. File number is 22-0234 FY. Council appearance.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
This is Public Defender Scott Nickel on behalf of Christina Bryant, also known as Jackson Bryant.
Thank you. Today is the date that was set for a preliminary examination. How are we dealing with this today?
Your Honor, we are requesting to adjourn the preliminary examination. Ms. Bryant is willing to waive the 21 days. We are trying to get screening done for mental health court as a part of the resolution in the hopes to work towards a positive resolution for both the case that exists here and a case that also exists in Eaton County. And so we are asking to adjourn the preliminary examination to allow that screening to take place.
No objection from the people, Your Honor.
Thank you. Ms. Bryan, can you hear me clearly, ma'am?
Yes, Your Honor.
Okay. How are you today?
I'm doing good. Thank you for asking. How are you?
No, I'm doing well, thank you. Today was the date that you were supposed to have your preliminary examination, but as indicated by your attorney, they're hoping to get you screened for mental health court, which would address this and possibly another case that you have pending. And so because of that, they want to adjourn your exam. Is that your understanding of what you're doing today?
Yes, Your Honor.
So you have the constitutional right to have your preliminary examination within 21 days of the date that you were arraigned. And so you're willing to waive that 21-day timeline, will get you a new date. You're not waiving the examination, just the time.
Yes, Your Honor.
Okay. April 1st. At what time? 8:30. We're gonna reset this for April 1st at 8:30 in the morning.
All right, thank you.
No problem. Any additional matters for the record?
No, Your Honor.
Your Honor, if we could address bond.
We can.
Currently, the bonds in this county is being held on. There's also a bond in another court, which obviously this court can't deal with. I'm requesting that the bond be adjusted to personal recognizance. She does have an address she can stay at, separate from the alleged victim in this case. It's my understanding that neither of them live at the apartment where this is alleged to have occurred anymore, but she does not intend to return to that apartment in any way. She will be supervised both by this county and by Eaton County, and so we ask that she be granted a personal recognizance bond while this case continues to be pending.
Your Honor, I would object. I would ask that our bond would continue the way that it is. That way we can ensure that she is present for any and all screenings for mental health between here and Eaton County. In addition, I understand the argument is that she does not reside in this apartment, and that's probably true. But the other party to this appears to be someone that she shares a child in common with. So the likelihood or the chance that they have contact due to that child, I would hope for the child's sake be high, but in this case, the bond and the her incarceration currently prevents that, which I think is safest for all involved.
Lieutenant is charged with assault with a dangerous weapon, a felonious assault, and then there is a domestic violence second offense. These are charges that are relatively assaultive in nature. And the bond that was set was pretty low, 7,510%. Then you said she has another matter pending, but more importantly, you're seeking an adjournment so that she could be screened for a specialty court. And the prosecution makes a valid point that we would need to make sure she's available to participate in that screening. And then she has another matter pending in Eaton County. What's the bond on that matter?
I am not 100% sure what a bond is in Eaton County at this point.
What's your bond in your Eaton County matter, ma'am?
5,000, 10%, 500, Your Honor.
What is she being charged with in Eaton County?
Similar charge.
Felony. Yeah.
A motion to amend bond is denied. I find the bond to be appropriate.
Thank you, Your Honor.
Thank you. Any additional matters for the record?
Nothing for the people, Your Honor.
Nothing further from defense, Your Honor.
Thank you. You're all set, Ms. Bryan.
All right, thank you.
Do we know what's going on with Comanche Clay today? Okay, and I see Mr. Leckleitner is here. We're running. You know where Deshaun Lewis is? Or Rodney Armstrong.
Okay. Okay.
You know where Lewis or Armstrong or Fly is?
Why, no, Lewis Armstrong was here.
Okay. Okay, let's see. Okay, we're on the record in the matter of the people of the state of Michigan versus Octavian Fly, file number 22-234 FY, council appearance.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor. Jeffrey Rawson appearing on behalf of Octavian Fly. I just called everywhere around outside, and Mr. Fly is nowhere to be found. I do not know where he is.
And prior to going to, on the record, you indicated that you did have contact with them last week.
I did have contact with him last week. It was not a very pleasant conversation. He hung up on me. I did mention to him that today was his preliminary exam. I believe communication is broken down to the point where I can no longer effectively defend Mr. Fly.
Were you retained on this or conflict counsel?
No, I'm conflict counsel.
So it was based on that communication last week,
Yes.
and then no further communication since then that caused you to believe that communication is broken down such that you're not able to provide him meaningful assistance of counsel?
Correct, Your Honor.
Have you been able to even go over any discovery with him at all?
I went over the discovery. I don't even believe he was listening when I talked to him over the phone. I did mail his discovery to him Friday afternoon. I do not know whether he's received it or not. I haven't had any communication with him.
I'll grant your motion to withdraw. A
Thank
bench
you.
warrant will be issued.
Thank you.
Thank you.
Okay.
It should be fine, but let's see. We have a big one going to ask for the clerk. Mr. Bigler? You can approach with the advice of rights. On the record in the matter of the people of the state of Michigan versus Matthew Raymond Leitner, file number 21-02204 FY. Council appearance, please.
Morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor. Attorney Jackie Moss appearing forward on behalf of Matthew Leitner, P79244.
Today's the date that was set for a preliminary examination. My understanding is that the defendant's going to be entered into a plea. Is that correct?
Yes, Your Honor.
Okay, can the prosecution place the offer on the record?
Yes, Your Honor. The offer is for Mr. Leitner to plead to an added count 4 of a disorderly person drunk in violation of MCL 7501671E. Misdemeanor punishable by up to 90 days and/or $500 fine. In addition, Your Honor, we're asking that the defendant agree to pay restitution. The amount is still to be determined. In exchange for that plea, Your Honor, the people would agree to dismiss the original counts 1, 2, and 3.
Okay, Mr. Moss, that's a complete and accurate understanding of the plea offer.
Yes, Your Honor.
Okay, Mr. Leitner, how are you?
Not bad, Your Honor. How about yourself?
I'm doing pretty good. And so you heard the offer that was just stated by the prosecution. Is that what you recall your offer to be?
Yeah.
You carefully considered that offer, sir?
Yes, ma'am.
And you would like to accept it today?
Yes, I do, Your Honor.
Okay, I have an advisory rights and plea information sheet that has today's date on it. Sir, is that your signature at the bottom there?
Yes, it is, Your
Did
Honor.
you read this document?
I did.
You understand the rights listed there?
Yes, ma'am.
And do you have any questions about any of these rights?
No.
You understand that you have the right to proceed to a jury trial in this matter?
Yes, sir.
At the time of your jury trial, you have the right to have the prosecution prove each element of the charges being brought against you. You have to prove each of the elements beyond a reasonable doubt. You want to accept the offer and plead guilty to the added count 4 of disorderly person drunk. You would have to give up your right to have a trial of any kind. Is that what you want to do?
Yes, ma'am.
That means you'll give up your right to cross-examine or question any witness that they intended to call. You're going to give up your right to call your own witnesses or present evidence to further any defense you believe you may have. You're also going to give up your right to remain silent at trial and not have silence be used against you. Do you understand that?
Yes, ma'am.
Anybody threatening you to get you to waive your rights and plead guilty?
No, Your Honor.
Anybody promising you anything to get you to waive your rights and plead guilty?
No, Your Honor.
Pleading guilty because you believe you're guilty. Are you pleading guilty because you believe you are guilty?
Yes, Your Honor.
Okay, as to the added count 4 of disorderly person drunk, how do you plead?
Guilty.
On a factual basis, please.
One more time.
I'm sorry, Your Honor.
On a factual basis.
Yes, Your Honor. Mr. Mr. Leitner, on or about the evening of June 19th, were you located in downtown Lansing, Michigan?
Yeah.
Did you consume alcohol that evening?
Yes.
As a result of consuming that alcohol, did you engage in conduct that would be considered disorderly?
Yes.
Were you yelling and shouting with persons in that presence?
Yeah.
Was there a physical altercation regarding persons in that presence?
Yes.
And this was a result of your alcohol consumption?
Yeah.
And the city of, downtown Lansing, Michigan is located within the town of Bingham?
Yeah.
Is your honor satisfied that a factual basis for the charge offense, drunken disorderly, has been satisfied?
I think you've established drunken disorderly, but there's I need something about the restitution if we're gonna order restitution on the drunken disorderly.
Oh, yes, your honor. On that evening, did you destroy or damage a vehicle?
Yeah.
Was that damage to the windshield of a vehicle?
Yeah.
And you yourself and only you caused that damage to the windshield?
Yeah.
Whose vehicle was it? Was it your vehicle? Is that a no?
No, no.
Okay. Do we know whose vehicle it was? Someone else's vehicle? Was it a police vehicle?
No, Your Honor, it was a civilian vehicle.
Okay. Any additional factual basis?
Nothing for the people. People are satisfied.
Court is also satisfied with the factual basis. I'll accept your plea. Find your plea made freely, voluntarily and intelligently. This matter will be set for sentencing.
Your Honor, if we may, we'd like to request immediate sentencing for Mr. Lightner.
Okay, there was a victim in this underlying charge,
Yes, Your Honor, there were 3 victims.
and restitution is supposed to be paid to a victim,
Yes, Your Honor, there is.
then we have to have it set it for sentencing, so that the victim has a right to appeal.
Understood, Your Honor.
Sentencing is going to be on April 14, 2022 at 8:30 in the morning. Prior to sentencing, you need to meet with probation so that you can have a pre-sentence report and recommendation provided to the court. You're also going to have to undergo a substance abuse assessment, okay? Is that a yes? Okay.
Yes, sir.
When you leave here, Mr. Moss can take you down and show you where probation is so that you can schedule your interview with them, okay?
Yeah.
Okay, thank you. Do you have any questions today?
No, ma'am.
Any additional matters for the record?
Nothing from me, Your Honor.
Nothing for the people.
Thank you. You're all set, sir.
Thank you, Your Honor.
Thank you, Your Honor.
Okay. You ready on Lewis? Mr. Petrovich, you're here on Comanche Clay. We're ready, Clay.
Yes, here.
Both of them, as you put them.
So both of those including what?
The other one is handled by Mr. Coleman, but my understanding is both of them.
Okay, sounds good. So did you want to do Lewis first, or how do you want to do it? It's up to you.
Or we could do Lewis first. I only need to take 2 witnesses on that one.
Okay, I'm ready to move on.
Yeah.
Mr. Abbott, we're gonna proceed with Lewis, is my understanding. Is this a witness on the list?
Yes, Your Honor.
Okay, so you haven't seen, we haven't called the case yet. Thank you. Okay, we're on the record in the matter of the people of the state of Michigan versus Tory Deshaun Lewis. The file number is 21-03108 FY. Can I have your appearances, counsel?
Morning, Your Honor. Andrea Lacey appearing on behalf of the people.
Good morning, Your Honor. John Abbott representing the defendant today. Seated to my right.
Thank you. And today's the date that was scheduled for preliminary examination. My understanding is that we're ready to proceed, but are there any preliminary issues we should address before we start?
There's nothing from the people.
Nothing from the defense, Your Honor. Thank you.
Thank you. You can call your first witness.
Your Honor, for their first witness, people call to stand Officer Jacob Martini.
Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
If you can have a seat there, officer. State your first and last name and spell them both.
Jacob Martini, JACOB MARCKINI.
So you can proceed.
Thank you. Can you please state your occupation for the record?
Yes, I'm a police officer with the city of Lansing, Michigan.
And how, sorry,
Go ahead.
how long have you been employed by the city of Lansing?
Approximately 3 years.
Now, Officer, I want to take you back to November the 12th, 2021. Do you remember that date?
I do.
And were you working in your capacity as a police officer on that date?
Yes, I was.
Were you working for Lansing Police Department on that date?
Yes, I was.
Do you remember if you were working alone or with a partner?
I was working as part of a mountain team.
Okay. So you were alone in your vehicle though?
Yes, I was.
Okay. And can you tell me if you were in a fully marked vehicle?
Yes.
Okay. And how were you dressed on that date?
I was wearing plain clothes with a khaki vest with police written on the front and back.
Okay. And on that date, were you present in the area of Jolly and Martin Luther King, or Jolly and Waverly in the city of Lansing, County of Ingham?
Yes, Jolly and King.
Jolly and Martin Luther King.
Yes.
What, is there anything located at that address?
Initially what happened is plainclothes detectives assigned to our unit were surveilling the Liquor King on South King.
Objection, Your
Okay.
Honor, not responsive.
Can you repeat your question?
Like, oh, my question was, is there anything specific located at that address?
What address?
Okay, objection is sustained.
Jolly and Martin Luther King, or is it just an intersection?
It's an intersection.
Okay, thank you.
Can you speak up a little bit, because I'm having trouble hearing you?
Yes, ma'am.
And what prompted you to go to that location?
Plainclothes officers assigned to my team were conducting surveillance of the Liquor King that had just been robbed at gunpoint a few days earlier.
Okay. And as a result of that surveillance, strike thing. Were you part of that team that was surveilling that area?
Yes.
Okay, and did anything that happened that night while you were doing surveillance catch your eye?
I was alerted to the fact that something had got the eye of one of the surveillance officers.
Okay, and without telling us what specifically was said, what did you do based on the information that you were given?
Determined that the vehicle tag was not like a traffic stop at the intersection between the car and the
Okay.
vehicle.
So you were given information about a vehicle,
Yes,
and then you did what specifically? Sorry.
conducted a traffic stop.
Okay. And what happened when you did that traffic stop?
Made contact with the driver, which is the defendant, seated over there in the blue shirt. I requested his driver's license, registration, insurance. He advised he did not have his driver's license. So I detained him for not having an operator's license on his person.
Let me stop right there. Your Honor, please let the record reflect that the witness has identified the defendant as being in the vehicle at this time.
Any objection to identification?
No, Your Honor.
Okay, identification is noted.
Okay, and what happened after that?
Because we believe that he was a wanted fugitive that we were looking for, that was known for the weapons history. He was leaving establishment that had been just robbed at gunpoint the night before. I conducted a theory that it was person.
Okay, and did you? What happened when you did that carry back?
I felt what I knew to be a gun in his right coat pocket.
Okay. And what did you do when you felt what you believe to be a gun in his right coat pocket?
We secured him in handcuffs and removed the gun.
And you would recognize that gun if you saw it again, is that correct?
Yes.
Your Honor, I'm showing what's been marked as people's proposed exhibit number 1 to defense counsel. May I approach the witness, Your Honor?
May.
Officer Martinez, I was calling you within that picture to tell me if you recognize that picture.
Yes.
And how do you recognize that picture?
Picture taken of a gun was taken out of the defendant's pocket.
Okay, and did you take that photograph?
I believe, I don't recall who took the picture.
Okay, but that is the gun that you recovered from the defendant's pocket, is that correct?
That's correct.
Your Honor, I would ask that this be admitted as people's exhibit number 1.
Any objection?
Objection.
One is admitted.
Permission to approach, Your Honor,
May.
and publish to the court.
Yes, please. Thank you.
What did you do after you removed the gun from Mr. Lewis's pocket?
Somebody else had several warrants for his arrest.
Okay, and at that point, what did you do?
Transported him to city lockup.
Okay. I have, the only other question I have, Officer Martini, do you remember approximately what the vehicle was that the defendant was driving at the time?
I don't remember.
But he was in a vehicle, is that correct?
Yes.
That's how you affected the traffic stop?
Correct.
I have no further questions, Your Honor.
Cross-examination.
Thank you. Morning.
Morning.
So you mentioned that you'd been alerted that this was a possible fugitive?
Correct.
And once they told you that, is that when you started following the car?
When it left the parking lot of the Liquor King, yes.
Okay. And had you run the plates before you left the Liquor King?
Probably when we were in the plate, whether it was before or when I was behind it.
But you had already decided to pull him over before you ran the plate?
No. It was all one solid motion. Does that make sense?
Sure, makes sense. So you received information that this was the wanted fugitive?
That it was believed to be.
Okay,
resembled,
did they give you a name for who they thought it was?
yes,
So you thought you had a specific person in mind?
yes,
And what was, okay, so you were pursuing this guy because you figured he was that one fugitive?
I wasn't pursuing anyone.
You followed him
Effectuated
south
traffic
on
stop.
Martin Luther King?
I'm sorry,
Didn't you follow him south on Martin Luther King?
yes, I pulled up behind him and I effectuated the traffic stop.
And at that point, you were right at the corner of, is it Miller Road?
No.
Where was it?
Jolly and King,
Charlie and King? Okay, so he turned left onto Charlie? Southbound on King?
yes,
Turned left onto Jolly?
after I initiated the traffic stop, yes, and pulled into the parking lot of the Deja Vu
Okay, so you initiated the stop while he was on King or while he was on Jolly?
while I was on King.
And is that because from wherever you started up by the Liquor King till you turned on your lights, you already run his plates?
Yeah.
Was it you that ran his plates?
Yes,
So at the time he left the Liquor King, you think anybody had run his plates?
I don't recall.
And once you got him out of the vehicle, you realized this was not the person you had originally been looking for?
I personally had never seen the film thing.
Okay.
What he looked like.
All right. So you didn't know whether or not the person in the car matched the description of the person you were alerted. You were looking.
That's correct.
Thank you, nothing further.
Thank you. Any redirect?
None, Your Honor.
Thank you. Officer Martini, you can be excused. Can you call your next witness?
No, Your Honor. I'm going to rely on Officer McKinney's testimony.
Okay, thank you. Is the defense calling any witnesses today?
No?
Okay, you can proceed to argument.
Your Honor, Officer Martini did testify that he was part of a surveillance team. He was alerted to a vehicle that they believe belonged to a wanted fugitive. He did surveil the vehicle. While surveilling the vehicle, at some point, he did run the license plate, which came back with an expired registration. Based on that information, he did a traffic stop. Believing that this person could have potentially been armed based on the information he was given to another officer, he did effectuate a Terry pat down and found that the defendant was in fact in possession of a handgun. At that time, it was removed from him. And he was in a vehicle at the time that he was transporting this handgun, Your Honor. People would ask that he be bound over as charged on the one count of carrying concealed weapon.
Mr. Evans.
Thank you, Your Honor. It sounds to me like this traffic stop was initiated before they had established probable cause that this was in fact the guy they were looking for. And it was only after they pulled him over, after they'd initiated the stop, that they realized he was driving a car with an expired license. He was never issued a ticket for the expired license. The officer testified that he didn't even know what the guy looked like. He was just told, alerted that this was the guy. Turned out it wasn't. So, Your Honor, as far as the basis for the stop, at the time that they initiated the stop, there was no establishment of probable cause. It was only after they pulled him over that they recognized that he had a license plate. The officer testified that he couldn't remember. It was all one motion, but it wasn't one motion. They alerted him that this was a fugitive. He pulled him over because he thought he was the fugitive. But there's been no demonstration from the people that this person actually met the description of the fugitive. We don't know whether it made any sense to pull this guy over, and he didn't even know what he looked like when he pulled him over. So I think that the stop itself was not based on a legitimate identification of probable cause. It was only after the fact they pulled him over that they recognized his case. Thank you.
Okay. Did you want any further argument?
Yes, Your Honor, I just want to point out again to the court that Officer Martini testified that prior to the stop is when he determined that the defendant had a expired license or registration. That is the reason for the stop to begin with. It wasn't necessarily that he matched the description, it's that the registration was expired. But while he may have been surveilling him because of that thought, he may have done the pat down because of that thought, the stop itself was based on the registration, which is a valid reason for stopping the vehicle.
Okay, today was the date that was set for preliminary examination. So for your information, sir, at the time of preliminary examination, the burden is that of probable cause. So the prosecution is only required to establish sufficient probable cause that a crime was committed and that there was probable cause to charge you with that crime. And that is a relatively low burden. This is not the burden that you're going to face at the time of trial if this matter is to go to trial, which is then beyond a reasonable doubt. This is a burden that is met here at this hearing, and it's based on the facts and evidence presented by the testimony. We had the testimony today of Officer Jacob Martini. His original testimony was that on November 12, 2021, that in the area of the Liquor King, which is in the city of Lansing, Ingham County, that there were plainclothes officers doing surveillance in the area, and that they alerted him of a vehicle that caught their eye. It was later determined that there was reason to believe, or he was at least alerted, that the driver of this alleged vehicle was possibly a fugitive that they were looking for. He testified originally that the vehicle tag was not valid. I do agree that it's a little bit muddled as to the sequence of events, and that when asked on cross-examination as to whether or not he ran the tags prior to the stop or after, he said it was one big sequence, essentially, of events. But that the tags were invalid, and that after the traffic stop, he asked the driver for a license, to which the other driver did not have a valid license on him, which caused him to be detained. I think that there is sufficient probable cause to bind over on the count one. Carrying a weapons carrying concealed. Again, based on that testimony that Officer Martini provided. Obviously, Mr. Abbott, you're at liberty to file any motions that you believe are necessary at the circuit court if you believe that the stop was not in sequence, but you would be able to have further information. The information you're providing now is just argument, but not based on any evidence that you presented to the court that they actually ran the tag after the stop. I don't know if that's something that you viewed on a body cam or not. I couldn't tell you, but based on his testimony, said he ran the plate and it was in one sequence, and we'll leave that to a trier of fact to determine what that sequence was.
So if the court doesn't mind, I'd like to ask for a point of clarification. That the basis for the stop, the hearsay statements that he used to describe why he was doing what he did, are those same hearsay statements being used to establish the probable cause for the stop?
He stated he was alerted to the vehicle by plainclothes officers.
Right.
And that he then began to follow the vehicle, and that he ran the tags and they were invalid. The tags came back invalid. Your question was as to the timing of when he ran the tags. And although not holistically clear, he said it was one big swoop. It's still his testimony that it happened all in sequence.
Right.
So that doesn't give the court reason to believe that he didn't run the tags prior to the stop. But that it happened, it all in one sequence.
Thank you, Your Honor.
So that's what the basis is gonna be on for probable cause. So this matter will be bound over to the circuit court for further proceedings. The bind over date is going to be February 23rd. You do not need to appear in court on February 23rd. That's just the date they'll get the file from this court. They'll set your next court date, which will be a pre-trial. Mr. Abbott will be made aware of that. Do you have any questions today, Mr. Lewis?
I'm sorry, man, I was speaking to my friend.
No problem. I just want to know if you had any questions.
Like, this thing that happened to me, like, I don't feel like that this is something that happens all the time, but like, as you can see, I was injured or whatever, you know, I went through my hospitalization and all that. When
Are
I
you
got out-
saying that you were injured as part of this?
No, I'm just saying,
Oh.
like, I'm just giving an example, like, you know, they say that I look like a fugitive when they, you know, they got attention to me, right?
That's what the allegation is. Again, I don't know what the description of the fugitive was. I don't have, none
I
of
don't
the
know either,
information.
but like, the point that I was making was like, you know, like, I was shot or whatever, you know, and I went to the hospital, I got out, and the person that shot me, after I made my foot, filed my complaint and everything, they was still riding around, calling my phone, making threats to me and everything, after I had given their whole name, description and all of that to the authority.
Okay.
So how can I look like a fugitive when it was an actual fugitive out here that was harassing me, that I turned in to them, that they just couldn't seem to find for nothing in the world? But they can say that they pulled me over because I look like someone. It doesn't sit right with me. I don't believe that at all.
I recognize that. I'm not, those two incidences, I just want to be clear, you're not alleging that they're connected.
No, they're not.
Okay.
It's just an example that I'm giving
Got
out. Like, I wasn't out here. I am not doing anything to anyone.
Again, sir, I don't know what the fugitive or the information about what the fugitive was. That wasn't information that was provided or needed to be provided to establish probable cause for this particular case. Now, it's up to your attorney if he wants to investigate the fugitives
Okay.
claim, you know, for your further defense, but as it relates for probable cause, again, a low burden. Whether or not a crime was committed, where there's probable cause that a crime was committed and probable cause that you committed a crime. Not the same as there was in fact a crime committed and you committed the crime.
Okay.
Probable cause is a different burden. Okay, so I think any further questions, Mr. Abbott can address with you off the record, but did you have any questions for the court? Okay, any additional matters for the record?
And none from the people, Your Honor.
None from this bench. Thank you, Your Honor, for addressing the questions.
No problem. Here is your exhibit.
Thank you.
All right, thank you.
I don't know. No one has done anything about it.
So what?
Got it all in there.
Yeah.
Your Honor, that's the second client in 2 weeks.
Okay, we're on the record in the matters of the people of the state of Michigan versus Comanche Clay, file numbers 21-03130 and 22-00218. Apply council appearances.
Good morning, Your Honor. Andrea Lacey appearing on behalf of the people.
And good morning, Your Honor. Robert Palmer of the Public Defender's Office. Appearing on behalf of Comanche Clay, the gentleman who's sitting to my right. I represent Mr. Clay in 21-03130-F1. And Charles Petrovich representing Mr. Clay with regards to 22-218 F1.
Thank you. Today's the date that is set for preliminary examination. Are we ready to proceed?
Yes, Your Honor.
Yes, Your Honor, the defense is ready to proceed. I do have one very quick preliminary matter at the courtroom. Your Honor, Mr. Clay is, he's brought his paperwork here with him, and he'd like to follow along. We would request that the court is willing to do so, that his right hand be allowed to be removed from the cuffs, if that's okay.
That's fine.
Other than that, Your Honor, I have nothing further, and we're ready to proceed.
Thank you. Anything from the prosecution?
Nothing from the people.
Mr. Petrovich, anything from you?
I have no further preliminary matters.
Okay, call your first witness.
Your Honor, for the first witness, the people call to the stand, Detective Ryan Kramer.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Thank you. You can have a seat there. You can state your first and last name and spell them both.
Detective Ryan Kramer, RYNCRAMER.
You can proceed, counsel.
Can you please state your occupation for the record?
I work for the Ingham County Sheriff's Office,
Okay, and how long have you worked for the Ingham County Sheriff's Office?
18 and a half years.
And Detective Kramer, I want to take you back to November 9th, 2021. Do you remember that date?
I do.
And on that date, were you working in your capacity as a police officer?
I
or
was.
detective? Thank you. Do you remember if you were working alone or with a partner?
I was working with a team,
Team. What team?
the VCI and SCP, the Violent Crime Initiative.
And can you tell me what the SCP means?
Secured Cities Program.
Okay.
for Michigan State Police.
And what kind of vehicle were you on?
I'm in an undercover vehicle,
Okay.
no markings,
And how are you dressed?
in plain clothes, no markings.
On that date, did you have the occasion to be in the area of 1516 Old Mill Lane in the city of Lansing in Ingham County?
I was.
Okay, and what's located at that address?
Trailer park.
Okay, and what prompted you to go to that location?
We had last seen Mr. Clay leaving a Speedway gas station headed southbound on Cedar Street towards that venue.
Okay, let me stop you real quick. Did you see him personally?
Prior to, well, leaving the Speedway or in the trailer park?
Leaving the Speedway.
Nope, we saw his vehicle.
Okay, and by we, are you referring to the team that you were
Members
working
on the team. Yes.
Okay, thank you. And you ended up in this trailer park,
Yes,
and that's based on what? You saw him heading to that location?
he was headed that way.
Okay,
We knew him to have previous contacts and things in that area.
okay.
And we were searching for his vehicle.
So you're familiar with Mr. Clay?
Very.
Okay. Can you please point to him and describe, or I'm sorry, the person that you're describing as Mr. Clay, can you please point to that person and describe what they're wearing to the court?
The blue Ingham County Jail jumpsuit, a mask with tattoos on his face.
Thank you. You're gonna please let the record reflect that the witness has identified the defendant.
Any objection?
Not for the purpose of the exam. Thank you.
Are you ready to proceed further?
And what happened when you were in the area of Old Mill Lane?
I was in there by myself, driving around looking for the car at first.
Let me ask you a real quick question. Vehicle, did you have a description of a vehicle that you were looking for?
Yes.
Okay. was that one that you knew Mr. Clay to be associated with, or just one, a description you had been given?
Both.
Okay,
It was a vehicle that had been described to us by Mr. Or that Mr. Clay to be driving for the previous couple weeks, involved in several other incidents with that same vehicle.
okay. And what happens when you're driving around?
I saw the vehicle, and as I slowly drove by the vehicle, I saw Mr. Clay sitting in the driver's seat. I went around to another part of the park, waited a little while, and then came back through so I could drive at him with my headlight shining at him so I could confirm that it was definitely him in the driver's seat. At which time I did visibly identify it as Mr. Clay in the driver's seat. I drove outside of the park, but back towards the entrance where the rest of my team was waiting for me. And then I turned around and I led kind of the convoy of marked and unmarked vehicles back through the trailer park to where Clay was located.
Okay. What happened next?
I drove by, clearly identifying the vehicle and that location of Clay. As I did that, vehicles, due to his history, attempt to immobilize the vehicle. As I turned around and came back to it, he was attempting to flee and was taken into custody.
Okay, can I, when you say attempt to immobilize, what do you mean?
Put cars on all sides of it so that he can't flee. There was a car directly in front of it, so we attempted to put a car on the side of it and behind it so he couldn't flee from us. We have an extensive history with him fleeing any police contact.
Okay. And you indicated that once the vehicles were surrounding his vehicle, he attempted to flee. What did he do
Yes.
that made you believe he was trying to flee?
He started the car, and I say started the car based on because the lights kicked on. I'm assuming that was the car starting. I couldn't tell if it was started before that, but the lights were off. But I saw the lights kick on, which indicated to me that he probably started it. And then as I was coming back towards him, I saw the lights on the back kick on, indicating that he probably put it in gear, and then I heard a loud rev of the motor, and he ran into a parked vehicle that was directly in front of him, as well as almost running into an undercover vehicle and undercover officer while trying to get out of that area.
Okay.
But hitting the parked car, I think, is what immobilized him the most.
Okay. Can you tell me when you noticed the car's lights go on and all of that stuff, were the vehicles that were present, did they have lights and sirens activated at this time?
Yes, that's when the fully marked state police trooper cars, I remember if we had 2 of them or 3 of them that day, were on the back corners of the vehicle, and they turned their lights on is when that reaction took place.
Okay, so from what you could tell, when those lights went on, that's when the vehicle that Mr. Clay was in also activated its lights.
Correct.
Thank you. Can you tell approximately how far he was able to get in the vehicle before he hit the parked car?
I would estimate 10 feet or so.
And what happened once he hit that parked car?
Once he hit the parked car, I was circling around to get to the driver's side to help secure him, at which time the window was broke out of the car because it was locked and he was not unlocking it.
Okay, let me stop you real quick. You say you're circling around. Are you in your vehicle at this time still?
No, I've exited my vehicle on foot wearing full police tactical raid vest with clear markings identifying myself as the sheriff's deputy.
Okay, so you're walking towards the vehicle?
Running.
Oh, running, sorry.
Yes.
Okay, so you get to the vehicle,
Mhm.
and then what happens?
As I'm getting my car into a position to help maintain our perimeter, I guess, and I'm running, I could hear them giving loud verbal commands for him to open the door, open the door, open the door. I heard the window get broken. And as I got around, Mr. Clay was being removed from the driver's side window.
Okay. And did you have any contact with Mr. Clay at that point?
Yes.
Okay, and what happened when you had contact with him?
Clay knew me from previous contacts and started talking. I told him, calm down, relax. We started to pat him down and removing evidence from his body. He was obviously in handcuffs. Summarizes it. There were two other people in the vehicle that had to be removed and controlled as well. So
Okay. Do you know who those two other people were?
do I?
Yeah.
No, they're indicated in my report. Though.
Okay. Did you have any contact with either of those people?
I talked with a female.
Okay. And without telling us what she said to you, did you determine whether you needed to continue to detain her?
We determined that she was not involved and was released from the scene.
Okay. And what did you have any contact with that third person? That
I
was
did not.
okay. Do you know if that was a male or a female?
It was a male.
Okay. And what did you do after that?
I went with, I don't remember how Mr. Clay was transported to the hospital. He went in the patrol car ambulance, but I met them at Sparrow where he was located.
Okay, so he was taken to Sparrow,
Yes.
and what did you do when you made contact with him there?
I Mirandized him and interviewed him.
Did he speak with you?
Yes.
What did he, let me ask you this. Do you know if anything had been found in the vehicle that he was driving at the time?
Yes, at that point, the narcotics paraphernalia and firearms had all been recovered. And he had ammunition on his person that matched the caliber of the firearms recovered as well.
Okay. And are those the things that you interviewed him about?
Yes.
Okay, and did he make statements to you?
Yes.
And do you remember what those statements were?
He confessed to possessing both of the firearms in the car, stating that he got them from his cousin in the past, I think, couple weeks is what he said.
But he knew that they were in his vehicle at the time?
Yes.
Did he make any other statements to you? With regards to what was
None
found
that
in-
really pertain to the incident itself.
Okay. Did you have any further involvement in this case?
Other than processing evidence,
Yeah, when you say processing evidence, what do you mean specifically?
tagging it in, sending the guns to MSP for NIVEN comparisons and things like that.
And just so I can be sure, you're not the person who retrieved those firearms that you mentioned from the vehicle, is that correct?
I did not remove them from the vehicle, no. They were turned over to me immediately at the scene.
Okay. And do you remember who those came from?
Officer Riley and Trooper Jupin were on that side of the vehicle. I believe they both observed them, which one actually physically removed it, I'm not positive.
Can you tell me what kind of handguns were handed to you?
It was a .22 caliber handgun and a modified Ruger 1022 rifle. Had the stock cut off, so it had a pistol grip on it.
I'm just gonna clarify for my purposes, is that something that's commonly known as a short barreled shotgun or rifle?
Rifle, yes.
Okay. And that's due to the modification, is that correct?
Yes. Overall length.
1 second, Your Honor, sorry. I have no, further questions for the witness.
Cross-examination.
Thank you. Morning.
Good morning.
I want to start by asking questions about the vehicle. You indicated that the vehicle that you were looking for had been associated with Mr. Clark, is that right?
Yes,
Could you give us a description of what the vehicle you were looking for was?
it was a multicolored, I want to say it was a Nissan. Very unique colored, spray painted in parts vehicle.
Okay, spray painted in
Like
in
rattle
parts.
can painted the bumper, the rear bumper. I want to say one of the quarter panels was mostly rattle can painted.
Okay,
Very distinctly unusual vehicle.
okay. And you said that you had, and I can't recall, but you said you had, either you or others in your team had previous contact with Mr. Clay, is that right?
All of us have. All of us have had several contacts with him. I've had quite a few as well.
Understood, okay. Was your previous contact with Mr. Clay associated with that vehicle?
No, not mine personally, no.
All right, so you had never, and I guess you developed, your team developed information that he was associated, he being Mr. Clay was associated with this vehicle, though, is that right?
Yes,
Was the vehicle that you found at the trailer park on that evening consistent with the report you had gotten regarding the vehicle?
yes. We'd seen it multiple times that night as well.
Okay,
It wasn't just locating it in a trailer park. We'd seen it multiple times in passing, but we couldn't get undercover vehicles back to follow it in time. So we'd seen it in that area several times that day.
understood. All right.
It was, to
I'm
be, I mean, more specific, the vehicle was described as dropping off an overdose subject at the corner of Bailey and Baker earlier in the day. The exact vehicle description, Mr. Clay's description is the driver. The vehicle was very similar description. Mr. Clay as the driver was described as conducting a drive-by shooting in a venue that same week. So there are multiple reports of Mr. Clay in that vehicle.
Understood.
Leading up to that evening.
Okay. And you said that when you finally located the vehicle in the trailer park, that several, I guess you said that you found it first and then you went back and retrieved your team. Is that right?
Correct.
All right. And so when the team entered the park, all of you pulled up at relatively the same time. Is that right?
Yes.
And you personally were driving an unmarked vehicle, right?
Correct.
All right. And I guess just to make a clear record, by unmarked, I mean, there was nothing on the outside of that vehicle to identify that it was associated with law enforcement.
That's correct.
And just so that we set the scene here, when you saw Mr. Clay's vehicle, were there other vehicles that were sort of impeding you and your team's access? If that question makes sense. If not, I can refer you.
Yes and no. I mean, there were other vehicles around it,
Okay.
but he could have driven out from where those vehicles were. We were able to set up to prevent that.
Yeah, okay. And let me try to clarify what I'm asking here. When you approached the vehicle and the vehicle that you're driving, when you approached Mr. Clay's vehicle, where were you your vehicle in relation to Mr. Clay's?
I had driven, Mr. Clay was parked near the front yard of the address on the report.
Okay.
I drove past Mr. Clay, allowing the other vehicles to set up and the two trooper cars to get directly behind it. So I drove past the vehicle, pulled into a driveway, turned around and came back. And by the time I came back, there were other cars between me and him.
Okay, so just so we make a clear record, I know you were gesturing with your hands. You're saying that Mr. Clay's vehicle was parked along the front yard, is that right?
Correct.
So the driver's side would be towards the road.
Correct.
And you drove past and then circled back. If I'm understanding you correctly, you kind of came in at like a 45-degree
Yes,
angle to the
we had
front.
several of our vehicles all around his by that point.
All right.
By the time I got turned around and they activated their lights and I got back there, there were vehicles everywhere.
Understood. Now you activated, or your vehicle would not have had lights on, right?
Correct.
And at some point, Mr. Clay's vehicle starts up and drives off. Is that right?
Attempted to, yes.
Or attempted to drive off. You said it made it about 10 feet, that vehicle did?
That's my estimate.
Okay.
There wasn't a ton of room between undercover cars that had pulled up, patrol cars, and a large Ford Excursion that he ended up running into.
Okay.
In that area. I'm guessing 10 feet from the bumper of his car to the large tire on the Excursion that he ran into. Is an estimate.
Okay, yeah, that's fair. All right. Did he, at some point, I think you indicated that at some point the vehicles, the emergency vehicles or the police vehicles turned on their overhead lights, is that right?
Correct.
Do you know whether Mr. Clay's vehicle started moving before or after those lights were turned on?
I think afterwards, but I can't say for sure.
Okay, fair enough.
Because I had driven past it and was in the process of turning around and watching it as I was coming back towards it.
Okay, and you're at a 45-degree angle, sort of off the front driver's corner, right?
Yes, behind another undercover vehicle where Mr. Officer Zolnine.
Okay, so there's another undercover vehicle there, and the vehicles involving the police, the ones that are the marked vehicles are behind his car, is that right?
Correct, at both back corners of the vehicle, with the lights and sirens activated.
Okay. Did, and I know you said you're not sure about the, about whether or not the Mr. Clay's vehicle started driving away before the lights of the marked cars went on. Do you know, did officers make announcement about who they were prior to the lights going on? If you know?
I don't recall.
Okay.
I heard lights and sirens on.
Okay.
I don't know if they're, it's not common to give verbal commands over a siren, so I
Sure.
can't say.
Sure, okay. And then ultimately there were firearms found in that vehicle, right?
Correct.
If you know, was the vehicle itself actually registered to Mr. Clay?
I don't believe it was.
Okay.
No.
And do you, if you recall, do you know who it was
I
registered?
don't recall.
Okay, that's fair. And there were 3 total occupants, is that right? of the
Yes.
vehicle? Mr. Clay was sitting in the driver's seat.
Yes.
The female was sitting in the front passenger seat.
Yes.
And the other male was sitting where?
Back seat, I don't recall what side.
Okay, that's fair. Did you personally have any interaction with the gentleman in the back seat?
I did not.
Do you recall seeing the gentleman in the back seat trying to get out of the vehicle?
No, I was dealing with Mr. Clay while they were removing him.
While they were removing him, being Mr. Clay?
No, the passenger,
Okay.
backseat passenger.
Gotcha. And to clarify, the window, it was the driver's window was broken. Is that right? I'm sorry.
Correct.
All right. And Mr. Clay was pulled out through the driver's window. Is that right?
Correct.
The firearms, did you actually, I know you said you're not the one who retrieved them. Did you actually process those firearms at any point?
Define process.
Well, I guess, handle them or review
Yes,
them?
I took possession of them.
Okay. And you said it was a 22 caliber rifle, is that right?
And pistol.
And pistol. So both were 22 caliber.
Correct. To the best of my recollection.
All right. If you know, does a 22 rifle fire the same round as the 22 handgun?
Yes, they're both 22 long rifle caliber.
Okay. All right. So you're saying it was 22 ammunition that was found in the pockets of Mr. Clay.
He had 22 caliber long rifle ammunition as well as 38 caliber ammunition in his pockets.
When you visited Mr. Clay at the hospital, you indicated that you Mirandized him?
Yes.
All right. And then you took a statement from him, is that right?
Yes.
Do you recall Mr. Clay sort of fading in and out of coherence at that time?
My experience with Mr. Clay is very animated.
Okay, what do you mean by that?
He often has what I believe to be fake seizures upon contact with police. He has a seizure, but he's very coherent. 30 seconds afterwards and is willing to provide information on other things that they don't appear to be real to me. His reactions that day appeared to be the same way. He would pretend as if he was not feeling well, but if I asked him a question that pertained to something, he was very quick to answer. He knew the answer accurately. It was not. It was consistent with a Comanche play.
And if you know, was he tested to determine whether he was under the influence of any substances or alcohol at that time?
I did not subpoena any hospital records. He personally admitted to being under the influence of methamphetamine and heroin.
At that time?
Yep.
All right.
In the injuries he was being seen for at the hospital was a pistol whipping that occurred, I believe, a week prior, days prior to our contact with him. So he had been seen driving around at very high speeds. He had been, his injury that he was complaining of was nothing recent. There was nothing that indicated to me that he was unable to answer or provide information accurately.
I have no further questions.
Thank you.
Just briefly, Your Honor. Oh, Detective Kramer, I just want to make sure that I'm clear on the ammo that was found. You indicated that this ammo, based on what you know about it, could be used in either the handgun or that rifle. Is that correct?
Correct. It's 22 caliber, 22 long rifle is the caliber.
Okay.
Like just because it has rifle in it, it goes in a handgun as well.
Okay, so it could be used on either of those weapons.
Correct.
I don't have any other further questions, Your Honor.
Thank you, Detective. Excuse. For your next witness.
For the next witness, Your Honor, please hold call to stand, Officer Dan Zolnai.
Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth on the penalty of perjury.
Yes, Your Honor.
Thank you. You can have a seat. Please state your first and last name and spell them both.
A-A-M-E-S, last name is Zolman, O-L, and like Nancy, A-I.
Thank you. See, thank you.
Can you please state your occupation for record, Officer Zolnai?
I'm a police officer with the Lansing Police Department, currently assigned to DCI unit crime initiative.
And how long have you been working for Lansing Police Department?
Approximately 4 years now,
How long have you been assigned to DCI?
approximately a year now.
Officer, I'm gonna take you back to November 9th, 2021. Do you remember that date?
Yes, ma'am.
And were you working in your capacity as a police officer on that date?
I was.
Okay. Do you remember if you were working alone or with a partner?
I was working with the violent crime initiative team, comprised of a multi-jurisdictional team of officers.
And you were working for Lansing on that date as well?
Yes, ma'am.
Okay. Did you have a partner in the same vehicle as you? Or were you alone?
I was alone.
Okay. What kind of vehicle were you driving?
I was in an unmarked patrol vehicle.
And what kind of clothing were you wearing?
I was wearing plain clothes, but I had a tactical vest that belonged to the police and large reflective letters on the front and back of the vest.
Thank you. On that date, were you present in the area of 1516 Old Mill Lane in the city of Lansing, County of Ingham?
Yes, ma'am.
Okay, and can you tell me what's located at that address? Is there anything located at that address?
There is a mobile home located at that.
What prompted you to go to that location?
The violent crime initiative team was conducting a fugitive investigation on Comanche Play.
And that led you to that specific location?
Yes, ma'am.
Okay, and what happened when you got to that location?
We had officers that visually observed Comanche Play inside the driver's seat of the vehicle that was parked within the driveway area of that location.
Okay, and are you familiar with Mr. Clay?
Yes, ma'am, I am.
Okay, were you one of the officers who identified him in that area?
I was not officer.
Okay, what happened?
We had marked state patrol vehicles that are associated with our team. Those team members positioned the marked patrol vehicle behind Mr. Clay's vehicle, initiated the emergency lights. I took my unmarked patrol vehicle and placed it in the front of Mr. Clay's vehicle while it stopped there.
Okay, and what did you do when your vehicle was in front of Mr. Clay's vehicle?
Upon observing that Mr. Clay's vehicle wasn't moving at that moment, I exited my vehicle and went to go address Mr. Clay. At that time, the engine started on Mr. Clay's vehicle, accelerated the highway speed towards me. I had to actually put my foot on the front bumper because it was going to run me over. So instead of having it hit me, I put my foot on the front bumper, which spun me around to the driver's side. At that time, I addressed the rear seat driver's side passenger, who was last name that's correct.
Okay,
And he was attempting to get out of that vehicle after the state troopers initiated a traffic stop. I placed him back in the vehicle. He was reaching into his waistband. I threw my partner firearm on him and held him at gunpoint.
okay, let me back you up just a little bit. When you heard that engine start on Mr. Clay's vehicle, where were you positioned?
Directly in front of the car.
Okay, and you said he accelerated in your direction.
Correct.
And you said you put your foot on the bumper.
I had to put my foot on the bumper, otherwise I would hit my car. I could have get hit in my shins rather than put my foot in the car.
Fair. Where on his car did you make contact with the car?
The front driver's side.
Okay, and you said that this moved you in a way?
Correct. The force pushed me off to the side.
Okay, and you ended up where in relation to Mr. Clay's?
On the driver's side.
Okay. So you indicated you did have contact with that backseat passenger, correct?
Yes, ma'am.
Okay, and what happened when you had contact with him?
He was attempting to get out of the car, placed him back in the car, door was open. That time I saw him reaching for the waistband, and that's my training experience that if you're gonna carry a firearm, oftentimes it's in the waistband.
Okay.
Speak up, sir.
Yes, ma'am. He started reaching into his waistband. This is not a microphone, is it?
It's for her, but not for
So
me.
I apologize. I apologize. I was speaking like this microphone. I apologize for it. So he was reaching into his waistband. I believe that at that time, given my training experience as an officer, I know it was just very firearm. At this stage, concern for myself. At that time, I had my firearm drawn. I trained on him. I gave him directives not to move and stop reaching his waistband. So I had some backup to help me secure that gun. Ultimately, other officers were still focused on the driver, Mr. Clay, as he was the gentleman that we were conducting a future investigation on.
Okay.
But we believe him to be armed based on his weapons history and some information we have.
Okay. Now, once the backseat passenger stopped moving, were you able to identify anyone in the vehicle as the person you know as Mr. Clay?
Yes, ma'am.
And is he present in the courtroom today?
Yes, ma'am.
Can you please point that person and describe what they're wearing for the court?
It's Mr. Clay here. He's wearing a blue jump with a white undershirt. Long sleeve.
Okay. Thank you, Your Honor. Please let the witness or the record reflect the witness has identified the defendant.
No objection for today's meeting. Your Honor. Thank you.
Now, did you have any actual contact with Mr. Clay after this?
I did not interview Mr. Clay.
Okay. And did you have any contact with him at all?
I might talk to him or said something to him.
But nothing significant that stands out?
No.
Okay. Did you talk to that backseat passenger?
May have addressed them after the fact. I didn't take a statement from them.
Okay. Give me 1 second. Okay. What did you do after Mr. Clay was taken into custody?
We're looking around the vehicle. I was on the outside of the passenger side there. I could see just through the glass on the door that there's 2 firearms inside that vehicle on the passenger side. One's a rifle style weapon, the other one's
And I know you indicated it was a passenger side. Was it the front passenger or the rear passenger?
It was a front passenger. No.
Okay. And did you retrieve those firearms from the vehicle?
I checked them for safety first, running them both safe. Found that they both were loaded with a round inside the chamber of both firearms.
And sorry, but can you describe each gun to me, please?
One was a rifle style firearm. I believe that the handle was duct tape, if I remember serves you right. And then another one was a handgun. I believe there's photos of them.
There might be photos of them. I don't have that.
Okay.
But from what you remember, one was a rifle and one was a handgun.
One
is
was a
that correct?
rifle style, correct. One was
Do you happen to know the calibers by chance?
I believe they were 22 long rifle. My memory serves me right.
And you did indicate that both of the firearms had 1 round in the chamber.
Yes, ma'am. As a part of our protocol, we render weapons safe, locating them, and both weapons did indeed have a round chamber.
And did you know there was a passenger that had been seated there previously?
Yes, ma'am. I believe there was.
Did you have any contact with that passenger?
I did not.
Okay. To your knowledge, was she arrested for anything on the scene?
Not to my knowledge.
Okay. I have no further questions, Your Honor.
Thank you. Cross-examination.
Hey, Your Honor. Good morning, sir.
Good afternoon, sir.
All right, so I just have a couple quick questions for you. You indicated that when you arrived on the scene, you were in an unmarked car, is that right?
Yes, sir.
And you also were not wearing a standard police uniform, you were in civilian clothes, is that right?
That's civilian clothes with a vest that indicated police in the front and back.
Sure. When you arrived on scene, did you witness the vehicle?
I did.
All right. And I know that there were multiple cars that pulled up to the vehicle. Where was your car?
In front.
In front. All right. So I know that there was a big, I can't recall if it was a Chevy or Ford SUV, but there was a big SUV.
Certainly.
About how far do you think, if you recall, how far between Mr. Clay's car and that SUV?
Maybe 15 yards.
15 yards. And if I recall correctly, there was also another car that was sort of parallel to the Nissan. Is that right?
I don't recall.
That's fair. And you were positioned directly in front of his car. Is that right?
Correct. So if his car is facing this way, there's another driveway where that truck that you mentioned is faced right there.
Okay.
My car was faced right there.
Okay.
So I was head on to him, and he was right there. There was a small gap, not large enough for a vehicle to go through, and there was another unmarked car that split that gap behind.
I got it. And just since I know you were gesturing your hands, so to try to make a clean record here, I'm gonna try to describe that. And if I do it incorrectly or unfairly, correct. That's okay. So Mr. Clay's car was parked along the side of the road. then there was an SUV that was approximately, I think, 15 yards at a 90-degree angle.
I
Is
don't
that
believe his car was in the road. His car was up in the property of that lot.
right?
I
Okay,
understand.
okay,
And then, yes, you're correct. The 90-degree angle would be the next truck. That's in
Okay.
the driveway adjacent to the property.
and then your car is sort of at a, I guess, 45-ish degree angle.
I wouldn't say 45, but it ran and it was just slightly offset from his straight on. So it wouldn't be straight on, it'd be offset.
Got it. And you're filling the gap between the vehicles there so that to try to prevent the area. Is that right?
Yes, sir.
All right. And there were additional marked units on scene, correct?
Correct.
All right. The marked units, for the most part, were behind Mr. Clay's vehicle.
Correct.
Do you recall, well, let me ask you this way. Were you out of your vehicle by the time the marked units turned on their overhead lights?
I believe that the marking is turning the lights on in regards to the progression of the event.
I'm sorry, I couldn't.
In regards to the progression of the event, the
Okay.
marked units initiate the traffic stop. At that time, the UCs would come in and plug the holes, as you would say,
Okay,
and then exit.
okay. Do you know if Mr. Clay's car or vehicle started, or was it already running when you were on scene, or?
I don't believe it was running. The way I heard it, I thought it was starting. Could it have been running and then stepping on the gas when it's in park, causing that loud kind of combustion and,
Sure.
and exhaust? Possibly.
Okay. Do you know if his vehicle, if you recall, did his vehicle start moving before or after the lights from the marked cars turned on?
In regards to my recollection, I believe it moved after the lights had already been issued.
And again, I realize that you may not recall this exactly, but if you recall, how long between the lights initiating and the movement of the vehicle?
I don't recall. I have to review their in-car cameras.
And so you approached the vehicle. Well, I guess there was the incident in which you're saying he moved forward.
Correct.
All right. And you sort of stepped on the bumper to push. Was that for the purposes of pushing yourself away?
It was either that or get hit by a car. So some part of my body had made contact with the vehicle. I didn't want it to be my shins, because that's the case I'd fall over and ultimately that would not be good. So it was just a reaction to put my foot on there to bounce off.
Bounce off of it. All right. If you recall, did it turn at all, or did it just drive straight forward?
He was trying to split the gap. So the vehicle that we spoke about that was 90 degrees from that vehicle, as I said earlier, there was a gap between that vehicle and my UC. I don't believe Mr. Clay could have seen the other vehicle past that. Too dark.
Okay.
So I think he was trying to split the gap between the two.
Okay. Now, ultimately, you made contact with an individual in the backseat when you approached the vehicle. Is that right?
Yes, sir.
And the individual in the backseat was trying to get out of the vehicle.
Correct.
And at some point, he was, I think, pushed back into the vehicle. Is that right?
Correct.
All right.
And he didn't, and for the record, he did not get all the way out of the vehicle. He was attempting to get out of the vehicle.
Okay. And there was some point where he was like reaching, I believe he was reaching for his waistband. Is that right?
That's correct.
All right. And the fear then was that he might also have a weapon.
Yes, sir.
All right. With regards to the weapons themselves, let me ask you, the gentleman who was in the back seat, was he ever searched?
I believe he's been searched incidentally. He was taken into custody in regards to the place again. So I imagine that yes, he indeed was searched.
All right. And were you the individual who actually found the weapons?
In the front seat?
In the front seat.
Yes, sir.
All right. Well, let me ask you this: how many weapons total were?
I believe it's two.
Two weapons.
Yes, sir.
And I think you described them. One as a handgun, one as a rifle. Correct.
Yes, sir.
Where was the handgun found?
The front passenger compartment. Again, the photos that were taken. Refresh my memory, but we don't have them here.
Right. All right. And how about the rifle? Where was the rifle?
Again, the front passenger compartment.
Front passenger compartment.
Correct.
And there was a person who was sitting in that front passenger compartment. Is that
Yes,
right?
sir.
All right. And that was a female.
Yes, sir.
Did you ever personally witness Mr. Clay with the firearms on him or in his hand?
No, sir.
I have no further questions.
Thank you. Any regards?
No, Your Honor.
Thank you, Officer Zona. You can be excused.
Thank you, Your Honor.
Okay, you can call your next witness.
Your Honor, for my last witness, we will call to the stand Trooper Keegan Wright.
Fine.
Yeah.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can have a seat. Please state your first and last name and spell them both.
Keegan Riley, Keegan Riley.
You can proceed, counsel.
Thank you. Trooper Riley, can you please state your occupation for the record?
I work for the Michigan Department of State Police. I'm currently assigned to work the Secured City Partnership in conjunction with Lansing Police Department Violent Crime Initiative.
And how long have you been working for MSP?
Since June of 2012,
Almost 10 years?
coming up on 10 years, yes, ma'am.
I'm gonna take you back to November 9th, 2021. Do you remember that date?
Yes, ma'am.
And were you working in your capacity as a police officer on that date?
Yes, ma'am.
Were you working for MSP on that date?
Yes, ma'am.
Do you remember, were you working alone or with a partner?
I was working with my partner, Trooper Racy Jupin.
And what kind of vehicle were you in, Trooper Creepin in?
Marked patrol car,
How are you dressed?
wearing this uniform.
Full uniform?
Full uniform, yes, ma'am.
Okay, thank you. On that date, were you present in the area of 1516 Old Mill Lane in the city of Lansing, County of Ingham?
Yes, ma'am.
And what prompted you to go to that location?
We were working as a team with BCI in order to arrest Comanche Clay. We had information from Detective Kramer that he had located him inside a vehicle, that address.
Okay, and do you have prior knowledge of Mr. Clay?
I had not personally dealt with him, but I had prior knowledge, yes, from the other officers on scene, as well as viewed photos of him.
Okay. And what did you do with it when you got that information from Detective Kramer?
We came up with a plan together to effect an arrest on his outstanding warrant.
And what did you do?
Personally, I was the passenger inside of our patrol vehicle. When we arrived on scene and activated our emergency lights, the driver of the vehicle, Comanche Clay, attempted to start the vehicle in order to flee. He eventually got it started and tried to flee. He drove his car into, I think it was an Expedition that was like lifted on big tires in the neighboring like driveway. He drove his car into that while trying to get away, and his vehicle was, I don't know that it was immobilized, but he couldn't drive through it, so he was stuck there. Officers on the scene removed him from the vehicle and placed him under arrest. During that portion, I saw two firearms that were on the passenger side of the vehicle in plain view. There was a pistol and I think it was a rifle to begin with, where the stock had been cut off to make it shorter.
So it was modified,
Yes.
and it's commonly known as a short barrel shotgun or rifle.
I don't remember the exact measurements on it, but looking at it, I believe it was a short barrel rifle.
Okay.
After the arrest had been effective, I assisted with the search of the vehicle. During that search, I located a black case with some orange pills inside of it, inside the center console of the vehicle, and I turned those over to Detective Kramer.
Now, did you have any contact with Mr. Clay?
I didn't interview him or anything like that. I mean, I saw him there. I might have stood with him and held on to him at some point. I don't remember exactly. I didn't do any interviews or anything like that.
Okay, and the person that you remember getting arrested that night, is he in the courtroom today?
Yes, he's seated there with the white undershirt, the blue overshirt, mask with face tattoo.
Okay, thank you. Your Honor, please let the record reflect the witness has identified the defendant.
No objection for today's exam, Judge. Thank you.
If you remember, Trooper Riley, did someone affect the search of his person?
Luke Trooper Jupin did a search of this person.
But not you.
No, I did not.
Okay.
I may have been present for it, but I didn't actually take everything.
Is it fair to say that you don't remember that specific?
That's fair. That's fair.
Okay.
I don't remember that exactly.
That's fine. And did you have any contact with any of the other people present at this incident?
I didn't conduct any interviews. I'm sure I had contact in passing, but
Nothing significant.
no.
But it's your recollection that the emergency lights on your vehicle were activated prior to the defendant's vehicle moving. Is that correct?
Yes.
Do you know if the sirens were activated as well?
I'm sure the sirens were never activated. The way we initiated the emergency lights and we got out of the vehicle because his vehicle was turned off the drive. And it didn't look like he would be able to drive his vehicle out. We weren't sure. The hope was we would get him out of his vehicle before he would start it up and attempt to. So I don't believe our sirens were ever activated.
Okay. I have no further questions for, thank you.
Cross-examination.
Thank you. Morning, Trooper.
Good morning, sir.
I just have a couple of quick questions for you. So you were in a marked MSP vehicle, is that right?
Yes, sir.
And that was it one of the Tahoes?
Charger.
A Charger. So it was a car, not an SUV.
Yes, our
Right.
other partners, they have a Tahoe.
Got it. Okay. All right. Now I know that and we've heard testimony today that there was a combination of marked and unmarked units that made this stop. Is that right?
Yes, sir.
You're obviously in a marked unit. Yes. Your marked unit pulled up behind Mr. Clay's vehicle. Is that right?
Yes, sir.
The other MSP, at least, there was 2 MSP vehicles there that day?
I think there were 3.
3.
There might have been 4. We have
Okay.
4 that work most days.
Okay.
I'm just not sure off the top of my head if all 4 were working that day or if we only.
Okay. The other units that were not MSP vehicles, those were they all undercover or were there marked LPD vehicles there as well? If you recall?
So I don't believe there were any marked LPD units. And actually now I do remember we had at minimum 3 marked patrol vehicles, with one being a Charger, one being a Tahoe, and the other was either a Tahoe or an Explorer, but it was an SUV.
Okay.
But I know for sure our K9 unit was present.
Okay.
So I know his Tahoe was there. So there were at minimum 3, but
Okay.
I believe there were probably.
Understood. And the marked units, were those all located at the rear of Mr. Clay's vehicle?
I don't believe so. I believe, I know our car came up directly behind him,
Okay.
but the K9 Tahoe would have been, if I'm seated in the driver's seat here,
Sure.
would have been like right off
All right.
that direction, because I know he came around from the front.
So is it, okay, so you're saying, let me clarify this. You're saying, is you're seated in the driver's seat, are you talking about seated in the driver's seat of your patrol vehicle or Mr. Clay's vehicle?
Of Mr. Clay's vehicle. So
Okay.
there would have been a marked unit essentially in front and behind.
So, and I know you gestured with your hand, is it fair to say that it would be forward and to the left, kind of like, I think it was maybe a 45-degree angle that you gestured at? Is that fair, or correct me if I'm wrong?
That's roughly. correct.
Roughly fair.
It was toward the front of the vehicle.
Okay, all right.
Off the driver's side.
I'm sorry?
Off the driver's
Off
side.
the driver's side.
Yes.
Do you recall if the lights turn on from all 3 or all of the marked units at the same time?
They'd be roughly the same time. Usually if we see one of us turn them on, then everyone turns them
Everyone
on.
turns
That
on.
way you can kind of sync it up. We want to make sure people obviously know we are police.
Okay. And do you know, when you arrived on scene, was the Nissan, Mr. Clay's car, was that running?
It was not running.
It was not running. Were the windows fogged up in that vehicle?
The rear window was fogged up.
Okay.
And then I know the passenger window might have been spray painted completely over, like the
Okay.
rear passenger window.
Okay.
But I know the back windshield was fogged up.
Okay. And at what point, or if you recall, how long was it between the time that Mr. Clay's vehicle sort of started forward? Strike that. That was a terrible question. How long was it, if you recall, between the time the lights turned on and the time Mr. Clay's vehicle moved forward?
So the lights turned on. I can kind of like detail what I did and I can tell you when.
Sure. Let's do
So
that.
the lights turned on.
Mhm.
We got out of our patrol vehicle. His car wasn't started until we were like at the car saying, "We're the police, put your hands up," because the car wasn't turning over at first.
Okay.
Like it was trying to start, but wasn't starting. At that time, he got the car started, and that was when I know the marking that was off to the front, and so was Officer Zolnai, because I could see him. He's, plain clothes detective style, but he wears a carrier that says police across the front.
Sure.
And that was when Mr. Clay's car went into drive, and he tried to escape through that route to squeeze between the neighboring vehicles and the police vehicles, and Officer Zolnai had to jump out of the way to not get run over. So I would say it was enough time for me to get out of my vehicle and to walk to his vehicle before he ever even got it started.
Okay. And the lights are on at that point?
Yes, they were on before we ever exited our patrol.
Okay. Are there commands being made at this point?
Yes.
Thank you, Your Honor. I have no further questions.
None.
Thank you. Trooper Riley, you may be excused.
Thank you, ma'am.
Any additional witnesses?
No additional witnesses, Your Honor. I do have one piece of evidence. Your Honor, I do have marked as people's proposed exhibit number 1, a certified judgment of sentence for Mr. Clay from October 15th of 2020. But I would ask the this people to exhibit number 1.
Does it be certified? Any objections in certification?
No, Your Honor. As the court indicated, it appears to be certified. I don't think I have any basis to make an objection on the court rules, especially at the preliminary exam.
Thank you. People exhibit 1 is admitted. Are the people entering any other evidence at this time?
No, Your Honor.
Thank you. Thanks, please. Enter the witness or testimony.
No, Your Honor.
Okay, thank you. You can proceed to argument.
Yeah. Your Honor, we have had a testimony from 3 different officers, 3 different police agencies, actually, with regards to Mr. Clay's movements and things that were found in his vehicle on the night of November the 9th. We have had testimony from multiple officers that Mr. Clay was the driver of a vehicle in which they did find a handgun as well as a what is commonly known as a short barreled shotgun or a rifle. They did indicate that those weapons both were .22 long rifle caliber weapons. There's also testimony that there was ammunition found on Mr. Clay's person that would be able to be used in both weapons. Further, there's testimony that both weapons were loaded at the time of Mr. Clay's arrest. There is testimony that there were other individuals located within the vehicle at the time that Mr. Clay was arrested. Detective Kramer indicated that he did talk to the female passenger, and this is where all of the officers have indicated that these specific weapons had been found. He indicated that he did talk to that female, and based on the conversation that he had with her, he made a determination that she was not involved in either the previous offenses that Mr. Clay was alleged to have been involved in, or the current offense of carrying concealed weapons in the vehicle. She was released from the scene at that time. Obviously, we have the certified conviction showing that he was in fact a felon in possession of firearms at the time that he committed this crime, because he was carrying concealed weapon as well as carrying a short barrel shotgun rifle. We also have further testimony, Your Honor, that this was not a traffic stop, but this was an attempted to be an arrest. There were multiple units on scene, including multiple MST marked cars that had lights activated at some point. Trooper Riley, I think, did a very thorough job of explaining the sequence of events with the lights being turned on by at least their patrol car. However, he does believe that all the other MSP vehicles would have activated their lights at the same time. Again, he said he wants people to know that they are in fact the police. He was able to get out of his vehicle and approach the vehicle prior to, and make commands. He indicated where the police, hands up, those types of commands. And then that was all prior to Mr. Clay being able to start the car. After he started that car, we have information from both Riley, Officer Zolnight, as well as Detective Kramer, that the defendant was able to move his vehicle, albeit not a long distance, but he was able to at least move that vehicle in wherein Officer Zolnight felt that he was going to be hit by the car in some part. Well, he indicated, in fact, some part of my body had to touch the car. He did put his foot on the vehicle so that he would in fact spin off, and as opposed to getting hit in the shin, where he indicated that would have been very bad. Your Honor, so I think that the probable cause standard has been met for all 5 of the counts with regards to Mr. Clay, and I would ask that you bind over as such. Thank you, Mr. Palmer.
Thank you, Your Honor. Obviously, I will first acknowledge that the probable cause is a low standard. I'm going to, as to counts 3, 4, and 5, I'm just going to ask the court not to bind over for lack of probable cause. I'm going to leave my argument there. I'm going to focus my argument on counts 1 and 2, specifically the carrying concealed and the short barrel shotgun and rifle. And I'll try to be brief about this. Just with regards to carrying a pistol, or carrying a concealed weapon, count 1. The jury instructions make it very clear that there's a difference between carrying a pistol on your person or carrying a pistol in the vehicle. And when it's in the vehicle, the elements are that the pistol was in the vehicle the defendant was in, that the defendant knew the pistol was there, and that the defendant took part in keeping or carrying the pistol in the vehicle. I think it was a little bit ambiguous in terms of there were 3 occupants of this vehicle. The testimony from all of the officers was that both the pistol and the rifle were found in the passenger section as opposed to on Mr. Clay's person in the trunk. They were found in the passenger compartment, passenger side of the front seat, where another female was sitting. And although the testimony was that Mr. Clay made I guess, confession at the hospital later, the testimony was that he had received the guns at some point from a family member. There was no testimony about him saying, yeah, the guns that I put those guns in there or anything like that. And therefore, I would ask the court not bind over on count 1, because I don't know that there was any testimony today to support the third element, that is that the defendant took part in carrying or keeping the pistol in the vehicle. I think the best argument for today is with regards to count 2, the short-barreled shotgun and rifle. We've heard a bunch of testimony about and sort of some speculation and conjecture about how this was a short-barreled rifle, but I don't think that there's been any testimony today that would suggest that it meets the elements. And what I mean by that is criminal jury instruction 11.3 talks about the manufacture, sale, or possession of a short-barreled shotgun. And also that term is defined in MCL 750.222. There's specifically a definition as to what a short-barreled rifle means. And it specifically said, both the jury instruction and the statute specifically say A short barrel rifle means a rifle having one or more barrels that is less than 16 inches in length, or a weapon made from a rifle that has been modified so as to have an overall length of less than 26 inches. Now, we heard some testimony today about how the stock may have been on this rifle may have been altered in some way, that there was some duct tape around the handle, that it had this pistol style grip. We heard no testimony today, Judge. There's no photo entered into evidence. There is no testimony whatsoever in this record about the length of either the barrel or the overall weapon. And so I don't think that element has been met by probable cause, even though that's a reduced standard. I don't think there's anything to suggest that, or any evidence in this record to suggest that there was measurements of this particular rifle, or that it somehow was less than either the 16 inches at barrel or the 26 inches overall weapon length. So I would ask that the court dismiss count 2 for lack of probable cause on that, Your Honor. I have nothing further. And just to make a clear record, the part that discusses Judge short barrel rifle, that definition is 750.222 parent K. Subparent.
Any further argument from the prosecution?
No, Your Honor, I believe, I would leave it to the court discretion at this point.
Okay, thank you. Today is the date that was set for preliminary examination, Mr. Clay, and at the time of the examination, the burden is that of probable cause. So that's probable cause sufficient that a crime was committed and probable cause to charge you, the defendant, with the crime. The burden is relatively low. It's not enough. It's not as much evidence that would be required to prove your guilt beyond a reasonable doubt, but it needs to be more than just mere suspicion that a crime was committed. So we had testimony today from Detective Ryan Kramer, as well as Officer Zonai from the Lansing Police Department, and then Trooper Keegan Riley. They all testified to an incident that occurred on November 9, 2021 in the area of 1516 Old Mill Road, which would be in the city of Lansing, Ingham County, in which they were working with the Violent Crime Initiative, the Secured Cities Partnership, that they were searching or in search of the vehicle described to be driven by or owned by Mr. Clay. It was the vehicle was seen leaving the speedway and heading in the direction of the 1516 Old Mill Lane. Officers described their approach to the vehicle and creating a convoy. At least 2 of the officers testified to having prior experience or interaction with the defendant and were familiar with the defendant, who's at the time listed as a fugitive for other alleged crimes. They testified that when they approached the vehicle, there were commands, or at least one was in full uniform. 2 of them, I believe, were in tactical uniforms with the identification of police marked on the front and the back of their tactical vests, that they announced that they were law enforcement, that the defendant attempted to try to start the vehicle, didn't immediately turn over, and then eventually the vehicle started and put the vehicle in drive and hit and ran into another vehicle in his attempt to try to vacate or flee the situation. As to count 1, the defendant was charged with weapons carried concealed, alleging that he did carry a dangerous weapon, to wit, a pistol. Officers testified that all officers testified that there were 2 firearms found in the vehicle. They were found in plain view. One was described as a rifle style, one as a handgun. At least that's how Officer Zone described the vehicles, I think. uh, The argument that was made, I believe the argument that was made by Mr. Farmer is interesting because count one, which is the pistol, or carrying a pistol, and count two, which is a weapons, firearms, short barreled shotgun rifle. Again, that there were other individuals in this vehicle, and the weapons were again found in plain sight in the passenger side of the vehicle. I think the element of the testimony that gives the court uh, sufficient probable cause to believe that the defendant was keeping these items in the vehicle or knew that they were there and participated in keeping them there was the fact not only that he gave a confession to Detective Kramer that he had received the weapons from his cousin, but also that the ammunition for the weapons were found on his person. And so that is sufficient enough to give the court probable cause to believe that the defendant did commit count one, weapons carrying concealed, count two, which was the firearm short barreled shotgun rifle. Defense is arguing that we didn't have any testimony that sufficient to describe a short barreled shotgun rifle or shotgun / rifle. The complaint as written is not just charging him with possession of a short barrel shotgun, but it does say / rifle. But there was no testimony as to the size or a sufficient description for the court to believe that the type of rifle that was found was that of a short barreled shotgun or rifle. We didn't have any pictures presented to give a further description to the court. So I'm going to side with the defense on count two, and I'm not going to bind over on count two. That will be dismissed. As to count three, weapons, firearm possession by felon, I'm assuming that there's two counts because one is supposed to go with the rifle and the other is supposed to go with the pistol. Is that correct?
I believe so, Your Honor. It does look like there's a typo. That should have been specified one carrying concealed and one with the short barrel shotgun rifle.
Okay, well, the court finds that there's sufficient probable cause to bind over as to count three, because the court has bound over on count one. Count four will be dismissed because I'm dismissing count two. Count five, police officers flee and eluding fourth degree under the vehicle code based on the testimony evidence today of the officers. The court believes that there's sufficient probable cause to bind over as to count five as well. So count one, count three, and count five will be bound over to the circuit court. Count two and four will be dismissed. The bind over date is going to be February 23rd. Mr. Clay, you're not going to need to appear in court on that date. That's just the date that they're getting the file from this court. They'll set your next court date, which will be a pre-trial, and that date will be provided to your attorney. You also have, I believe, two new charges pending or two new files pending that I believe you're going to be arraigned on today.
That's my understanding, yes, sir.
As well as I think a couple of misdemeanor warrants. The bond in this matter was set at 15,000, 10%. That will continue. Any additional matters on this record, or do you have any questions on this file, Mr. Clay?
Your Honor, just in regard to bond, this is a tricky situation in this particular case. Mr. Clay is currently serving a sentence on a probation violation out of the 30th Circuit Court, but I believe the sentence technically ends today. The idea being that he could, once his sentence is up, he would be sent to TRICAP for treatment. Quite honestly, because I don't know the nature of the charges on which he would be arraigned. He's supposed to be arraigned later today. I don't know whether he's even eligible for TRICAP, but would the court consider a modification of bond that would allow him to go to TRICAP otherwise?
I was the one who issued the other two complaints coming through. I don't believe that he would be eligible based on those, but I'm not 100% sure. I'm not amending the bond.
I'm sorry.
I would not be amending the bond on this file
I understand.
or the other file for that matter. Any additional matters on this file?
Nothing from the people.
Nothing further. Thank you.
Thank you. And are we running an exam on the other one? We have witnesses on the other one?
Yes. Your Honor, if Mr. Petrovich doesn't have an issue, would I be able to take this to short recess? I have to go move my car again.
No, we're gonna take a recess. It's been a while.
Okay.
How many witnesses do you have on the other file? Here's your exhibit on this one.
Yes,
I have 3, potentially 4, but I think only 3 are here.
So you think that exam's gonna take longer than an hour?
I don't personally think that it should, but I
Okay, and then we also have to run, is it Codes Merchant?
yeah.
Oh. And you have all your witnesses here on Merchant as well?
Yeah, well,
Where's Mr. Austin? Did he leave?
I don't think he left. I do have 2 witnesses on Cold Merchant.
Okay.
There was only 3 subpoenaed and the 3rd witness did not appear, but
Okay, I would be inclined to do whatever one's gonna be quickest first, because we're gonna have to break the lunch.
okay. Just based on what I know, I think the Clay one would be the quickest, the Cold Merchant.
Sounds good. We'll recess for about 10-15 minutes. You can take care of your meters.
Okay. Thank you.
Mr. Austin, my understanding is that your client wanted to request an adjournment.
Yes, Your Honor, that would be me making the request on behalf of Mr. Coach Merton, Your Honor, if I may.
On the record in the matter of the people of the state of Michigan versus Cerise Coates Merchant, file number 22-00110 FY, council parents.
Good morning, Your Honor. Andrea Lacy, appearing on behalf of the people.
Good afternoon, Your Honor. Jared Austin, appearing on behalf of Ms. Coach Merchant. She is present, standing in my right.
Maybe today was the date that was scheduled for preliminary examination. Mr. Austin, would take a motion?
Yes, Your Honor, thank you. Ms. Coach Merchant has been rather nauseated all morning. She's been here, and recently she's been vomiting. And I would make a request to the court to find good cause to adjourn preliminary examination, Your Honor. Is my concern is to proceed with creating a potential appellate issue. And I just do not believe that she would be well enough to properly participate in the hearing or to assist counsel.
The prosecution want to respond?
Your Honor, I do have witnesses here, and we are prepared to proceed. However, based on the statements that Mr. Austin has made, I do think that it would be distracting to both myself, the witnesses, other counsel, and I don't think that it would be. I wouldn't have any objection to adjourning at this point.
Okay, this is your client here?
Yes, Your Honor.
Yeah. Are you not feeling well today?
No, I'm not going up in the conference room. We sit in the conference room all morning.
Okay. You have a constitutional right, ma'am, to have a preliminary examination within 21 days of the date of your arraignment. If we adjourn this matter, that means you would not have your examination within the constitutional time frame. So are you willing to give up your right to have that exam within 21 days? So we could set it for a new date?
Yes, ma'am.
Okay, and is it that you're not feeling well, or are you just nervous?
No, I'm okay to be here, but I just been nauseous all morning.
But you're okay to be here. But you're okay to be here then?
Yeah, I'm just nauseous.
Okay, well, then I don't see why we need to adjourn if she's okay to be here. We have witnesses already here, so we might as well get it done while she's here. She could be nauseous the next time she comes. She may be nauseous because of these charges. Who knows why she's nauseous?
I know she's in the middle of pregnancy, Your Honor, that may have an effect on that as well.
Well, that's it. It's information that should have been shared. She could be nauseous the next time she comes then. No reason to adjourn. I'm going to deny the request. And what I will do is not, we're going to run an exam. We can do hers first so that she can be gone if that's the concern. Prosecution?
It's up to the court, Your Honor.
Okay, we'll take Mr. Clay back to the jail. We'll do him after lunch. And then, Mr. Petrovich, you're free to go to lunch, I guess. And we'll run this exam now. And I'm imagining we'll probably won't be done with this for about an hour. So I would say for you to come back around 2, because my staff still has to have lunch.
Yep, I will return at 2 o'clock.
Thank you.
Treat my computer, Your Honor.
No problem. Okay, on the record in the matter of the people of the state of Michigan versus Cerise Coates Merchant. File number is 22-001110FY. Council appearance.
Good afternoon, Your Honor. Andrea Lacy appearing on behalf of the people.
Good afternoon, Your Honor. Jared Austin, bring on behalf of Ms. Coach Merchant. She is present with me at council table.
Thank you. Today was a date that was set for preliminary examination. Do we have any preliminary matters before we proceed?
Nothing from the people, Your Honor.
I would just ask for a general order of sequestration if there are multiple people or witnesses here, Your Honor.
Thank you. How many witnesses are there again?
I have two.
Okay. Are they lay witnesses or police witnesses?
One is a lay witness and one is a detective.
I'll grant the sequestration request. And you can call your first witness.
Thank you, Your Honor. The people for the first witness would call to the stand Ms. Jaleesa Hernandez.
It gets kind of warm in here. You might want to take your coat off.
Mind if I
Okay, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Thank you. You can have a seat there, ma'am. So there's a microphone in front of you, and there's a court reporter sitting right behind you. She has to take down everything that's being stated here today. I also need to be able to hear what you're saying, and we're wearing masks. So when you give your response, if you could speak up loudly and as clear as possible. If you do need to remove your mask so you can give testimony, I know it could be a lot to talk with the KN95 on. I will approve you to remove your mask for your testimony. You need to make sure all of your responses are verbal. You cannot give head nods and shakes because we can't write that down into the record. And then you can't do and we need yes or no, okay? Also try to keep your voice up again so that we can hear. If there's an objection, you would wait. I'll make a ruling on the objection, and then I'll instruct you if you should answer or not, okay? Can you state your first and last name, spell them both?
Jaleesa Hernandez, Jalisa Hernandez, Hernandez.
Thank you. You can proceed, Council.
Thank you. Ms. Hernandez, I'm going to take you back to September 29th, 2021. Do you remember that date?
I do.
Okay, and did something happen on that date that brings you to court today?
Yes.
Okay, and can you describe the first thing that happened that day that would bring you to court?
The defendant appeared to be shooting at me.
Okay, let me stop you real quick. You indicated that somebody is a defendant, is that correct?
Yeah.
And is that someone that you know from your personal life?
Yeah.
And who is that person?
Cerise.
Okay. And she's present in the courtroom today?
Yeah.
Okay. Can you please point to Ms. Coach Merchant and describe an article that she's wearing to the court?
White turtleneck with a jean jacket.
Thank you. Your Honor, please let the record reflect that the witness has identified the defendant.
Any objections to identification?
Without objection.
So noted. You can continue.
Ms. Hernandez, let me back up. What's your relationship with Ms. Coach Merchant, if any?
We don't have a necessarily relationship. I know her because my boyfriend at the time is her spouse.
Okay. Now back on September 29th of 2021. Did you guys have a relationship at that point?
The same as just mentioned.
Okay. Do you guys have any reason to be in contact with one another?
No.
On that date, did Ms. Coach Merchant have contact with you?
Yes.
Okay, and what kind of contact did she have with you?
We spoke over the phone, and we also had messages.
Okay, what kind of? The text messages, Facebook.
Facebook Messenger.
And can you describe to me what types of messages those were?
The nature of the messages were us kind of going back and forth in argument, and at the end of the argument, she was saying she was pulling up to my house. Do I want to?
Okay. Now, were you present at the time that she had indicated that she was at your house and asked you if you wanted to play?
No, I was not.
Where were you?
I was in a early.
And what did you do based on the message that you had received and the do you want to fight message?
Well, at that point, I didn't do anything. I just ignored her message, and I received a phone call from her while I was out, and she notified me that she was at my house and that she was going to start vandalizing my house. And so I called the police and let them know that there was someone threatening to vandalize my home, and asked if they would please go check.
Okay. And what did you do after you contacted the police?
Soon after, I left urgent care and went home to check on it myself.
Okay. And did you make it to your home?
Yes.
Was Miss Coates Merchant present at your home when you got there?
No.
And if you know, does she know where you live?
Yes.
Do you know if she's been to your house before?
Yes. She.
What happened after you went home?
After I went home, no one was there, and I called the police and notified them that they did not need to come out. I came to my home, that it was all in one piece. So it was not necessary for them to come, and I left again.
Okay, and where did you go with that?
I went to the dollar store.
Oh. And did anything happen on the way to the dollar store?
No.
Okay. You made it to the dollar store?
Yes.
What happened after the dollar store?
Left the dollar store and came back home, and on my way home is when I saw Cerise driving her red Equinox, and it appeared that she was leaving my home. She was coming off of the street that's right intersected with my street.
Okay, let me stop you real quick. You're familiar with this vehicle that she
Yes.
was driving?
Yes.
Do you know this vehicle to be her vehicle, or does it belong to someone else, if you know?
I know it to be hers.
Okay. And you believe that she was coming from your house?
Yes.
Okay. Approximately how far were you from your house when you saw her?
Less than a half.
Okay. What did you do at that point?
Well, I was at a stop sign, so I was just, the driver and I were stopped at the stop sign.
Okay, were there other people in the car with you?
Yes.
Okay. Who all was in the car with you?
Marquise Salon was in the car with me, and a child.
And where were you sitting?
I was in the passenger seat.
Okay, and Mr. Salon
was driving.
And the child?
In the back seat, behind the driver.
Okay. Now, when you first talked to the police after this incident, did you tell them a different seating arrangement in the vehicle?
Yes.
What was that?
I told them that there was just me and a child in the car, and I left the Marquise out.
Okay. Is there a reason that you did that?
Yes. The Marquise and I have a no contact order from we are both on probation.
Okay. And is that through Ingham County?
No, it is.
Eaton County?
No.
Oh, which county is
We
it?
have probation through Isabella County.
Isabella County, sorry. Okay, so initially, when you talked to police officers, you left him out because of that no contact order?
Yes.
Okay. Back up to the stop sign. What stop sign were you at, if you remember, if you remember?
I was at the stop sign on Bayview and Sheffield.
Okay, and what happened at that stop sign?
Well, Cerise was driving. And she was, I'm not exactly sure how to explain it. We were at a stop sign and she was coming across us.
Okay, so she would have been driving past your car.
Yeah, she was driving past us. So I seen her driving and her window was apparently halfway down, appeared to be halfway down.
Okay.
And she looked at us, we looked at her, and once she was on the side of us, this is a one-way street, so once she was on her one way, heading back towards the other way, that's when she was.
So I just want to make sure I'm clear for the court. So you're facing one direction and her car is going like perpendicular to your car? Okay.
Is that a yes?
Yes.
And are both of these streets one way?
No.
Okay. Which street was a one way? Her street?
My street.
Street you were on? Okay. And you said at some point she looked at you. That was her vehicle was directly in front of your vehicle? Okay. And then what happened after that?
She turned on to her side of the street, which would go back towards Waverly, and as soon as she was on the side of us, shots were fired.
Okay. So at this time, is her car directly next to yours?
Not directly, because there's an island in between that area. So in between the island, her car was.
And her vehicle at this time is going opposite direction of your vehicle.
Correct.
Okay. And you indicated that at that point you heard shots being fired?
Yes.
Okay. Now, were you able to see where shots were being fired from?
Not in the exact location of the car.
Okay. Did you see anything like a muzzle flash or a gun at any point?
I did see a muzzle flash. I did not see.
And can you tell me where you saw that muzzle flash come from?
It appeared to be on the driver's side. I'm just not sure which door.
Okay. So you're indicating the driver's side of Miss Coates' merchant vehicle.
Yes.
What did you do when you saw that?
Well, I heard it before I saw it, so I was kind of just shocked that it was happening. I reached over to the back to try and move the child from behind the driver, and I called the police.
Okay. Were you scared at that point?
Yes.
And at that time when you saw Miss Coates' merchant vehicle, were you able to see if there was anyone else in the vehicle with her?
I seen that there was someone in the passenger seat.
Were you able to see if there was anyone in the back of the vehicle?
No.
And was there something?
Let me clarify that. Is it no that she couldn't see, or was there no one in the back of the vehicle?
No, I could not see if there was someone.
And was there something obstructing your view?
The windows of her truck are tinted in the back. They have a bit of a tint, so I was not able to see.
Okay. And do you remember approximately how many shots you heard?
About 7.
And if you remember, are you able to tell us if it was coming from one gun or multiple guns?
Was not able to tell.
Did the vehicle that you were driving in, was it your vehicle or was it Mr. Solom's vehicle?
It's my vehicle.
And did your vehicle get hit by any of the bullets?
Yes, there were 5 bullets, one in which went through the back seat of my car.
And was anyone injured?
No.
One second. Do you remember where the other bullet holes were in your vehicle?
Yes. I believe the majority of them were in my driver's side door. One actually went through the door and
And based on what you know of Ms. Post Merchant, were you afraid that it was her that was shooting at you at the time?
yes.
And is that based on prior contacts you had with her?
Yes.
Objection leading.
Sustain the objection.
And when those, you were hearing the gunshots, were you afraid that someone was trying to hurt you?
Yes.
And did you, at that time, believe that someone could have hurt you at that time?
Yes.
Ms. Hernandez, when you were receiving those messages about wanting to fight with Ms. Post Merchant, did you respond to those?
No.
Did you intend to engage in a fight with Ms. Post Merchant?
No.
Have you ever been engaged in a fight with her before?
No.
Sorry. Ms. Hernandez, based on what you know about Ms. Post Merchant, do you know if she is known to you to be in possession of handguns?
Objection, post speculation.
You want to address the objection?
Your Honor, if this is based on her knowledge of the defendant and whether or not she is known to her to have handguns, I think that would go to establishing whether or not she was reasonably afraid that Miss Coach Merchant was in fact the person shooting at her from the vehicle in which she saw the defendant driving and the muzzle flash come from.
I think she could testify if she knows as to whether or not the defendant has or has been in possession of a firearm. I'm not sure I'm following the speculation part.
Well, and it may very well, Your Honor, it's not clear from the way the question is worded, whether she would be answering based on her own personal knowledge or observation or based on what someone else told her.
Okay. I'll allow her to rephrase the question then. To
Okay.
that
Thank you.
extent, I'll sustain the objection. Can you rephrase the question?
Yeah. Ms. Hernandez, based on your own personal knowledge of the defendant, do you know of her to have handguns or weapons? No. Based on what you know of her, on your own knowledge of her, you know, if there are people that she hangs out with that do.
Sorry, I didn't catch the question. I didn't hear the question.
I asked if she knows if the defendant is known to hang out with people who do possess weapons.
I'm going to sustain the objection. You don't answer that.
Thank you. Your Honor, I have no further questions at this time.
Thank you. Cross-examination.
Yes, Your Honor, thank you. Good afternoon, Ms. Hernandez. The shooting incident that you were describing, what time of day or night are we talking about?
It was around 10 a.m.
It would have been rather light out then.
Correct.
And you were describing Cerise in a vehicle, a red Equinox, that was kind of perpendicular to your car because it was stopped at a stoplight. Is that correct?
My car was stopped at the stop sign. Her car was passing in front of it.
Correct. And what type of speed was her vehicle traveling? Was it a normal speed? Was it at a high rate of speed?
It was a normal speed. It was a little slower than.
And is this a residential area that you're describing?
Yes.
It would have a slow speed limit around that area, is that correct?
Yes.
And were there any other vehicles that you saw moving on the road other than the red Equinox and your vehicle at that time?
There were no other vehicles on the road.
And you stated that you saw a passenger in the vehicle, is that correct?
Yes.
Were you able to recognize or identify who that person was?
No.
Were you able to tell whether it was a man or a woman?
I could only see the hair, and the hair seemed to be a hairstyle of women.
Were you able to tell the race of the person?
No.
And you remember what kind of clothing Cerise was wearing that day when you saw her in the vehicle?
No.
And then you stated the windows on the Equinox were tinted, is that right?
Of the back.
But not the front?
Correct.
And how about your vehicle? Did they have tinted windows?
My Taurus, yes.
On the front windows, like the front passenger, front driver side windows we're
Yes,
talking
not
about?
yes, the front, all windows except for the front windshield.
So no tinting of any kind on the windshield?
Correct.
And you stated you were not able to see whether or not there was another person in the back of this red Equinox, is that correct?
Is that a yes?
Yes.
And you're not able to pinpoint exactly where in the vehicle the shots were coming from, is that a fair statement?
Correct.
And you did not see a gun?
Correct.
You did not see Cerise with a gun, correct?
Correct.
And Are you able to describe kind of the rhythm or the cadence of the shots? Do you know what I mean when I say that?
No.
Were they all rapidly in succession, like bam, 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 bam? Were they spread out?
No, they were just in this one.
One right after the other?
Yes.
Were you able to tell whether the vehicle was still driving, the red Equinox I'm
Yes.
talking about, while the shots were being fired, or was the vehicle stopped?
The vehicle was stopped.
And DeMarquis's last name is Solomon, is that, am I saying that?
Salon.
Salam?
Yes.
And you don't deny that when you were initially talking to the police about this, you did not tell them that he was in the vehicle,
I
correct?
do not deny that.
And you told them that you were the one driving the vehicle,
Yes.
correct? And that was a lie when you told that to the police, correct? And they later confronted you about that once they found out that he was in the vehicle. Is that true?
Not necessarily how it happened, but eventually, yes.
Well, you had a subsequent conversation with the police after the initial report, correct?
Yes, however, I spoke with my probation officer before I spoke.
But you did speak to law enforcement after making the initial call, correct?
Yes.
And they brought to your attention about DeMarquise being in the vehicle and you leaving that information out, correct?
Yes.
And were you able to see the license plate on the Equinox at all?
No.
Do you know what Cerise's license plate number is?
No.
And I believe you stated just right before the shooting, when you saw the red Equinox, you believed it was coming back from the direction of your house. Is that correct?
Yes.
Okay. And your house was not vandalized then, either,
No.
correct?
Correct.
And have you spoken to anyone prior to today about what your testimony was going to be in court today?
No.
Have you reviewed any statements or police reports prior to testifying today?
No.
All the question I have. Thank you.
Thank you. Any redirect?
No, Your Honor. Thanks.
Thank you. This witness may be excused. Then you can call your next witness.
Yes, Your Honor, for the next witness, the people called to stand Detective Trooper John Doherty.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can have a seat there, Trooper. And can you please state your first and last name and spell them both?
My name is John Brady. It's Jon, last is BR81.
Counsel, you can proceed.
Can you please state your occupation for the record?
I'm a detective trooper assigned to the Secured Space Partnership in the city of Lincoln.
And what agency do you work for?
Michigan State Police,
And how long have you worked for Michigan State Police?
about 5 years.
And in your role as a detective trooper, are you assigned to investigate follow-ups for cases?
Yes, ma'am.
Okay, and were you assigned attempted shooting of a Lisa Hernandez with a suspect Sharif Coates Merchant?
Yes, I will.
Okay, and if you remember, what day were you assigned to that case?
I'm not sure what day I was assigned.
Do you know if it was relatively recent to the incident?
It was.
And with regards to your role as a detective on this case, what did you do to investigate this incident?
Conducted interviews, consent searches, search warrants on electronic devices.
And did you also review evidence submitted by other officers?
I did.
With regard to the interviews that you conducted, can you tell me, did you interview a Jaleesa Hernandez?
I did.
And if you remember, did you interview her one time or multiple times?
I interviewed her once at her house and then a couple of times over the phone.
And with regards to the initial interview, you said that took place at his house, is that correct?
I did.
Based on the interview you had with her, what did you do to investigate the case?
Following that interview, I made contact with the suspect and attempted to identify other people that were in the vehicle. Got consent to search cell phones, search a vehicle. Locating additional evidence that I could.
And in your role as a detective in this incident, were you aware of any physical evidence that was recovered from the scene?
Yes, there were shell casings collected from the scene.
You happen to know how many shell casings were recovered?
I do not, top of my head, no.
Do you remember by chance which officer it was that recovered those?
I believe it was Officer Liveson, but I'm not sure.
And when you review this, did you review the evidence that she received or recovered?
Yes, those casings were taken to the lab.
And what is the intention to do with them in the lab?
Taking them to the lab, you can you can attempt to see if they were fired, or if that same gun fired similar casings in any other incidents. Depending on the case, you can attempt to get biology or fingerprints off the casings, if it's challenging to do.
Do you know if any of those tests were conducted?
Yes.
Okay. What tests, if you know, were conducted?
There were no NIBIN matches for those guns. NIBIN would be the system in which they identify if that same gun is fired around another scene where casings were collected.
Okay, so essentially no matches to a separate scene.
Correct.
Okay. With regard to other interviews, did you interview the defendant in this case?
Good.
And do you remember when you interviewed her?
Interviewed her on 2 separate occasions. Don't have the exact dates. Once was at the interview rooms at the operation. The other was down at the county jail, and then we exchanged a few phone calls throughout the investigation.
Okay. So you think 2 instances?
Yes.
Okay. Now, with regards to the interview that took place at the Lansing Police Department, did Miss Coates Merchant make any statements to you with regards to this incident?
He did.
And what were those statements that she made to you?
Initially, she denied having any involvement or knowledge of the incident. As the interview went on, she later said that she had been at the scene at the time of the shooting, had heard the shots, however, said that someone else had done the shooting. I spoke with her about messages that I had from her cell phone that had been screenshotted and sent to me by the victim.
And with regards to her saying that someone else had done the shot, did she indicate that they came from inside of her vehicle?
In that initial interview, she said that they had come from a separate vehicle. She described the white sedan, I believe.
And did you later determine whether or not there was in fact a separate vehicle?
Yes.
And was there a separate vehicle?
No.
And when she indicated that someone else had done the shots, did she at any point tell you who that someone else was?
In the initial interview, she gave the name of a person named Trey.
And were you able to determine who that person was?
I was.
Do you know, is that their correct name?
Trey is a nickname. I forget what his legal name is.
And with regards to the text messages, what did she indicate to you about those text messages?
There were a set of messages stating that she was going to the victim's house in order to have a physical altercation or cause some altercation there. She had stated that she had not actually gone to her house. There were other messages that said "we missed you on purpose" that were sent to the other victim in this instance. She said that that was not regarding the shooting, but was not clarified what that message was pertaining to.
She did not clarify at all what else that could mean.
She would just say that it meant something different.
And was there anything else that she said during that first interview that stuck out to you?
She gave the name of a cousin that was in the vehicle with her at the time.
What was that cousin's name?
In that initial interview, she said that the cousin's name was Alicia Alex.
And was that determined to be a real person?
No, it is not a real person.
What is the cousin's real name, if you know?
Brittany Dukes.
And is there anything else that was relevant to this incident that was made, statements made during that initial interview?
Just that as the interview progressed, she was willing to place herself at the scene, said that she had heard the shots, said that she did have issues with Ms. Hernandez, Mr. Salon.
Was that essentially the most relevant information from that first interview?
I believe so.
And based on the name that she gave you for Trey, did you do any follow-up investigation with regards to, I'm assuming it's a him?
Yes, I did.
Okay, and were you able to find out any information about this person?
Yes, so I believe that Ms. Coates Merchant had indicated that Trey was an ex-boyfriend of the victim. I was able to reach out to the victim and determine who Trey was. I was able to get a phone number for that individual and speak with him.
Okay. And did you interview him as well?
Over the phone, yes. We went to a date.
And based on your interviews with him, did you determine that he was in fact in the vehicle or in a separate vehicle at the time of the shooting?
I was able to determine he was not involved.
And with regards to Brittany Dukes, were you able to do any investigation with regards to her?
What?
And what did that lead you?
I was able to conduct an interview with Ms. Dukes at LPD operations as a condition of a probation hearing that she had. In that interview, she stated that she had been in the vehicle, as well as two other people in the vehicle at the time of the shooting. She had seen the shooting. And was able to determine that Ms. Merchant was indeed driving the vehicle at the time of the shooting.
Did she tell you the name of the person that actually did the shooting?
She said the shooting came from one of the individuals in the back seat. One of the individuals was her brother. I forget what the other individual's name was. Say shots came from the back.
Okay. And anytime, let me just back up real quick. After these interviews took place, did you then interview Ms. Coates Merchant for the second time? Or was there something in the interim that was being done?
I had interviewed Ms. Coach Merchant the second time prior to the interview with Ms. Dukes.
Oh, okay. And this is the one that took place at the English County Jail, correct?
Yes.
And during that interview, did Ms. Coates Merchant make any statements to you regarding this incident?
During that second interview, the name of the cousin that was in the vehicle was changed to Leah Davis, which is a Facebook name for Brittany Dukes. She confirmed that she was indeed at the scene of the shooting. And also confirmed that she had gone over there after sending the text messages about having a confrontation with the victim.
Let me back up real quick. You said she went over there after the text message confrontation with the victim. Where is there specifically?
Yes, to the victim's house is right around the corner from where the shooting took place. The text messages indicated that she was going to the victim's house.
And you're saying that the defendant told you that she did in fact go to the victim's house, is that correct?
Yes.
Okay. All right, go ahead. What else did she indicate to you?
They were leaving the area and saw the two victims in the same vehicle driving into the area, turn the corner, and that is when the shooting occurred.
And at that point, did she tell you who had done the shooting?
No.
Did she tell you that it was coming from her vehicle at this time?
No.
Did she tell you it was coming from a separate vehicle?
I do not remember if she said separate vehicle in that second interview. I don't believe she did.
Okay, so she indicated to you that she was present when the shooting occurred.
Yes.
And is there anything else that she said to you with regards to this incident?
You know, toward the end of that interview, she was beginning to shut down a little bit, said that we needed to speak with him, like you still on. Gave a few other names that we needed to speak to other individuals. However, we didn't offer any more information.
At any time did she indicate to you that she knew this was going to take place prior to it taking place?
In the first interview, she did.
What did she say with regards to that?
She had made comments about it not supposed to be going as far as it did. And obviously the text messages following stating we missed you on purpose. And there was another text message sent to Mr. Salam that, you know, I'm about to kill you, right? And I believe that was sent prior to the shooting.
And she indicated she discussed all those things with you?
We spoke about them.
Okay.
Yes.
And did she admit to sending that text message to Mr. Salam?
Yes.
And has it indicated to you based on your prior experience and training as a police officer that this is something that she knew was going to take place or was reasonably likely to take place? Is that correct?
Yes.
Did she indicate to you that she had set this in motion or set this up?
Yeah.
And what did she say with regards to that?
I remember. The text messages speak to her going over there for some sort of confrontation. She had indicated that she had called the individual in the first interview when she had said that Trey had done the shooting. It indicated that she had called him over to that area where she was parked at, she said her father's house in that same neighborhood. After they had a discussion, she said that Trey followed her out, and as they were leaving, that's when the shooting occurred.
Okay, and did she indicate to you that Trey was supposed to do the shooting?
No, she would not say that she had orchestrated the shooting, so just that she had gone over there for an altercation, called other people to that area. And the text message prior to saying, you know, about the code.
Keep your voice up, please, and repeat the last statement.
I said in addition to the text message prior to and after saying, you know, I'm about to kill you and we missed you on purpose.
Was there anything else during either the first or the second interview that statements that she made that stick out to you with regards to the incident?
Not that are coming to me in this moment, no.
At any time, did you affect any search warrants? You said on phones, correct?
Yes, there was a search warrant conducted on the phone. I also had a consent search for her vehicle and a separate cell phone that she had with her. They were both signed by her.
The phone that you used the search warrant for, who did that belong to?
Ms. Postmarker.
And you were able to find those text messages that we've already discussed and she already talked about with you.
I was, so I had them both on the phone and screenshots sent to me by.
Okay, and you said she had a second phone?
Yes,
You did a consent search on that, is that correct?
I did.
Was there anything different that you found on that phone? Or that was helpful in this case?
The consent search is the phone, excuse me, the consent search is the phone that had the text messages on it. The phone for the search warrant, I did not believe had anything of evidentiary value that I found in.
Okay, so consent search on phone, text messages she already discussed with you, search warrant turned up essentially nothing.
Correct.
Okay, and is there another search warrant that you indicated or something?
There was a consent search for her vehicle when she came to be interviewed at LPD.
And was there anything found in her vehicle at that time?
No.
Do you know approximately when that consent search took place?
It would have been dated the same day as the interview.
Okay.
The first interview. I believe in October.
And this would have been approximately 2+ weeks after this incident took place, correct?
Correct.
Apologize. Did you attempt to set up a polygraph examination for Ms. Coates Merchant?
I did.
If you can explain to me what it was that you were hoping to gain by the polygraph.
Just to develop some level of truthfulness, and then more so, I think the value would have been in the interrogation following the polygraph conducted by the polygraph exam.
And did Ms. Coates Merchant appear for that exam?
No, she did not.
Was there any reason given for that?
There were a few reasons given. The one that she had given to me was that she was discussing with her attorney on whether or not to go. She also said that she had other things to do that day and would reschedule. I got a phone call from her probation agent who stated that Ms. Coates Merchant.
Object to hearsay.
Do you want to respond to the objection?
No, Your Honor, that's fine.
Objection is sustained. You can tell us what the probation officer told you.
Understood, ma'am.
You cannot tell us what the probation officer told you, okay?
Understood.
So without telling us what the probation officer said, they did contact you.
Yes.
And there was another reason given?
Yes.
Okay. Detective Brady, at any time during your interviews with Ms. Coates Merchant, did she indicate to you whether there was an intended victim in this case?
She at one point had said that she did not realize that Mr. Salon had been in the vehicle, but outside of that, did not mention an intended target. No.
And during those interviews, did she indicate that she knew that this particular vehicle belonged to Ms. Lisa Hernandez? Okay. But based on the text messages, you believe that she was shooting with Ms. Hernandez that morning?
Correct.
Did she indicate to you that she was familiar with Ms. Hernandez?
Correct.
So that they had issues?
Yes.
At any point, were you able to look at the victim's vehicle in this matter?
I did see her vehicle when I interviewed her at her house. Yeah.
And did you observe bullet holes in that vehicle?
Yes.
And if you remember, do you remember how many you observed and where they were located?
I believe there were 5 or 6. I'm not sure exactly how many, but they were all along the driver's side.
Okay, I have a further question.
I just have a question before we go to cross. Because Trooper, Detective Trooper, you discussed collecting shell casings from the scene. But you never said where the scene was. Where was the scene?
Sheffield and Bayview, ma'am.
Okay, is that in the city of Lansing, Ingham County?
Yes.
Okay, thank you. Cross examination.
Sean, thank you. Good afternoon. Is it detective, is that your title?
Yes, sir.
Good afternoon, sir.
Good afternoon.
So I understand that you were speaking earlier in your testimony, I believe, about regarding some of the shell casings that were recovered. Is that correct?
Yes, sir.
And there was some type of test performed on those to see if what? If they had been fired from a gun that may have been involved in a prior incident. Is that?
That is one of the tests that can be done, sir, yes.
And there was no matches on that particular test. Is that correct?
Correct.
So that would mean whatever firearm this was had not been used in another crime. Is that what that signifies?
At least not where shell casings were collected.
And I understand it correctly, earlier in your testimony, you stated that you were able to determine that there was not a second or separate vehicle at the scene apart from either Ms. Hernandez's or Ms. Coates Merchant's vehicle.
Yes,
Is that
sir.
correct? How were you able to make that determination?
With an interview with the victim, sir.
So, in other words, Ms. Hernandez said there were no other vehicles there.
None that were observed, correct.
Okay. And when you say you made the determination that there were no other vehicles there, you're basing that just on what she told you?
Yes, sir.
Just a moment. Are you okay, ma'am? Yeah. Okay, if you need to take a break, you can let us know. You can continue.
And did you do any type of investigation to see if there was anyone in the neighborhood that may have seen or heard this incident?
I did, sir.
Was that you personally that did that, or some other officer conducted that?
Both.
Were you able to locate anyone that may have seen or heard?
Yes, sir.
How many?
I believe there were 2 neighbors. I believe, sir.
And there wasn't anyone that was able to say that it was Ms. Coates Merchant that did the shooting, though, is that correct?
Correct, sir.
And you stated that you had spoken to or interviewed Trey.
Yes, sir.
And your understanding is that was the former boyfriend of Ms. Hernandez?
Yes, sir.
And he did not say that Ms. Coates Merchant did the shooting, did he?
No, sir.
And you told us that you also spoke to a Miss Brittany Dukes that claimed to be in the vehicle. Is that correct?
Correct, sir.
Okay. And she never stated that Miss Coates Merchant did any shooting, did she?
Correct, sir.
Did you interview DeMarquise Salon?
I attempted to.
I think you were unsuccessful.
He was not willing to speak with me, sir.
Did you try to ascertain from anyone in the neighborhood if there was any type of security cameras that may have captured?
Yes, sir.
And was there any camera that did capture the entire event?
Not the entire event, no.
That's all the questions I have, Your Honor.
Thank you. Is there any redirect?
No, Your Honor.
Thank you, Detective. You can be excused.
Thank you, ma'am.
You have any other witnesses?
No, Your Honor. I believe the other officer that was subpoenaed did not appear this morning.
Thank you. So the prosecution resting at this time? You have other evidence?
No, Your Honor. People rest at this time.
Thank you.
We'll rely on the evidence presented, Your Honor. Thank you.
Thank you. You can proceed to argument.
Your Honor, I understand that the defendant is charged with 5 counts, with count 3 and 4 being assault with intent to murder and a felonious assault upon a D. Marquise Salam. Based on Mr. Salam's unwillingness to participate, the people are going to ask that we're going to dismiss those charges. It is clear that he was present in the vehicle, Your Honor, but been unwilling to participate this far, cooperate with police, and will be otherwise unable to sustain the burden of proof necessary at a trial for those counts without his participation. With regards to the remaining counts, count 1, assault with intent to murder, or in the alternative, felonious assault, and count 5, weapons, firearm discharge from the vehicle. Your Honor, I would indicate that she is charged directly with being the person to do these acts. It's been made sufficiently clear by this evidence that there was someone else in the vehicle with her that did these acts. Therefore, the people, if Your Honor is willing to find over on the theory that she either was an aider and abetter, or that she was an accessory after the fact, Your Honor, Ms. Hernandez was clear that she had been having an argument with defendant over a phone and Facebook message, wherein the defendant had reached out to her and asked her if she wanted to fight. Victim indicated that she was intending to ignore this and not engage in any type of altercation with the defendant. She in fact called the police because she was concerned about what the defendant could do at her house, and then canceled the police when she realized that no one had been there, no one had done anything to the house. Then she indicates that she does see the defendant driving from what she believes to be the direction of her house at a later time, where the defendant actually places herself at the defendant's home. So in the interview with the detective, indicates that she was in the area where the shooting took place. There is testimony from Ms. Hernandez that she heard, I believe she heard approximately 7 shots. She was unable to determine if there was one gun or multiple guns. Her vehicle was struck, and she indicated that there was about 5 bullet holes in the vehicle following this incident, which is substantiated by the testimony of Detective Trooper Brady, who did also view a victim's vehicle at the interview that he did with her. Ms. Hernandez did indicate that she did see the defendant driving the vehicle that she knows belongs to the defendant. The defendant looked straight at them, and when she turned the street facing the opposite of their direction of their car, the vehicle was then stopped and shots were fired. She did indicate that the shots were fired from the vehicle when she saw the muzzle flash, and she indicated that it was on the driver's side of the defendant's vehicle, but she was unsure whether it came from the defendant or somebody in the back seat. She did indicate that she at no time did see the defendant with a gun, but those gunshots in the muzzle flash was coming from the defendant's car and her general direction. Ms. Coates Merchant, while talking to police officers, she puts herself at the scene of the shooting. She indicates that she did hear shots. She did give officers multiple names of other people that were in her vehicle. She did attempt to explained to Detective Brady that a person by the name of Trey had potentially done the shot. However, that person was interviewed by Detective Brady and determined to not have been even present at the scene or involved. Further, the defendant made statements to the victims, one that we missed you on purpose, we being that she was not alone in this incident, where she clearly admits not being alone during this incident during the time of the shooting, and she had sent a text message to DeMarquis Salam saying, you know, I'm going to kill you. Prior to this incident, she did indicate to the officer that she did not know he was present in the vehicle at the time, but we know that he was the driver of the vehicle. So if she was driving, she would have been able to see him. She does give the officer, when she was being interviewed, she did give a number of names. She did try to obscure or at least provide names for a cousin that were not her true name, Brittany Dukes. Brittany Dukes was further interviewed, also places herself at the scene. She indicated that there were two other people in the back seat of the vehicle, and Ms. Dukes indicated that somebody in the back seat, whether it was her brother or a separate person, was one of the individuals that actually did the shooting. Unfortunately, neither Ms. Dukes nor Ms. Coach Merchant appear to be interested in helping the officers determine who, in fact, perpetrated the shot on Ms. Hernandez's vehicle. She did indicate to the officer, based on statements where she said this incident went too far, that she knew that something was going to take place prior to this incident. She did intend to confront the victim. She did call others to the area to have some sort of conversation with the victim. Furthermore, Your Honor, the defendant or detective did attempt to set up a polygraph examination to determine whether or not Ms. Coach Merchant was being truthful. Obviously, she had given him some reason to doubt whether or not people that she was indicating in the car were actually the people in the car. Also, the unwillingness to give up the last person in the vehicle. Your Honor, so we're asking for this to be gone over based on an aiding and abetting theory. The elements for that, of course, are that the alleged crime was actually committed either by the defendant or someone else. We know that there was a shooting that took place in the presence of her vehicle, whether it was her or somebody in the backseat of her vehicle, we're still unsure, but she was present at the time of the shooting. The victim did suffer no injuries to herself, but to her property. I would argue that her asking people to come to the area and indicated to the officer that she called Trey and had him come with her and try to set up that type of confrontation with the victim will be sufficient for that element, at least at this stage in the process, and that she intended the commission of the crime alleged or must have known the other person intended commission, or that the crime alleged was a natural and probable consequence of the commission of the crime intended. Again, Your Honor, those text messages that she sent to both victims, the one that said, we missed you on purpose and I'm going to kill you, you know I'm going to kill you, sent to Mr. Salam, would indicate to me, at least circumstantially, that she knew ahead of time what was going to happen, or that somebody was going to do something along those lines, because she seemed very, this text messages seemed very pointed to me. I don't think there was any question at the time of what was going to happen or what she intended to happen. Alternatively, Your Honor, she could also be charged under the theory of being an accessory after the fact. Obviously, someone committed this offense. Not something that I have to prove who, or that they've been charged or convicted of that offense. That she helped the other person in an effort to avoid discovery, arrest, trial, or punishment. I would argue to the court that her failing to provide that name of somebody who is potentially out on the street and capable of doing this again would satisfy that element. because it is helping that other person avoid discovery, arrest, trial, punishment. And that when she gave the help, she knew the person had committed a felony. I don't know if Mr. Austin is gonna make an argument that she wouldn't know that shooting a gun from a vehicle constitutes a felony, but I think that most people would agree that that would be something that seems felonious in nature, considering how high the stakes are and the possible consequences of such thing. And that the defendant intended to help the other person avoid discovery, arrest, trial, or punishment. Again, Your Honor, failing to provide law enforcement with that name of the person, if in fact she is not the one who did the shooting, satisfies that element for me at least. So I would ask that you find her over on the 3 remaining counts under either or both of those theories.
Mr. Austin?
Thank you, Your Honor. The session by the people seems to be that Ms. Coach Merchant did not directly participate in any shooting that occurred. I would certainly agree the evidence states that, and I think it goes well beyond that, Your Honor. So since they seem to be conceding that Ms. Coach Merchant did not do the shooting, now they are left to take this shotgun approach and hope that something sticks in order to meet their burden of having the matter bound over for trial. Essentially, what they are left to argue with then is that either Ms. Coach Merchant was engaged in some type of conspiracy with whoever this other unknown person was who did this shooting, that this is someone that she knew was going to do this shooting, and that she was somehow a participant in either the planning or the carrying out of that shooting. I don't see that there has been any evidence presented here today that would satisfy the court on a probable cause standard that has occurred. There certainly an even weaker argument that I believe they're making, Your Honor, is that somehow Miss Coach Merchant is, if they cannot convince the court that she was aiding and abetting whoever did the shooting in some way, now they're left to argue then that, okay, if she didn't know about it when it was happening, or if she didn't know about it beforehand, now she is an accessory after the fact, which essentially what their crux of their argument is that her failure to disclose the identity of this shooter would somehow constitute an accessory after the fact. That makes an awful lot of assumptions. That makes the assumption that Miss Coach Merchant knew who this person is, which again, the evidence and the testimony that has been presented, Your Honor, has been, I think, rather conflicting. And I don't believe that there has been any credible evidence presented that Miss Coach Merchant knew the identity of this person and she was refusing to disclose that to the police in an attempt to protect this person whom she would have known or should have known had committed a crime or a felony. Assuming she knew the identity of that person, and I think there could be just as a rational explanation, assuming what they're saying is true, and I'm not conceding that it is, but let's say that it is true. I think there is every bit a rational explanation, if not a more rational explanation, is that if Miss Coach Merchant, for whatever reason, knew the identity of this person, was not disclosing it, is that she was doing so out of fear or some type of retaliation. I think that would make more sense than she is doing so in some effort to thwart justice or to assist this person in getting away with the commission of a crime. So, Your Honor, I understand the burden at this stage is probable cause. I acknowledge that that is a low hurdle, but nevertheless, that is a hurdle that they must cross, and I do not believe with the evidence that has been presented here today, that they have met that threshold. Certainly, again, no direct evidence of Ms. Coach Merchant participating in the shooting. They seem to concede that. There did not seem to be any testimony or statements from any of the other witnesses that seemed to indicate, that were interviewed by law enforcement, that there was some type of plan or conspiracy that Ms. Coach Merchant was a participant in, that would make her criminally liable for the actions of somebody else. It's very weak, circumspect. I think it's tenuous at best, and I would ask the court to deny the motion. And Your Honor, if the court does believe that they have demonstrated in some way that Ms. Coach Merchant is responsible, either as an aider or abettor theory or an accessory after the fact, as a secondary argument, I would argue, Your Honor, that they have not met their burden as it relates to count one, that if the court is convinced that some assault took place, that Ms. Coach Merchant is responsible for, either as an aider or abettor or an accessory after the fact. I think the evidence would suggest that at best there was some felonious assault that took place versus an assault with an intent to murder. Thank you.
Thank you. Today was the date set for a preliminary examination. At the time of the examination, are you okay?
Yeah. I'm trying, I have a trash can right here, just in case I need it.
Okay, if you need to take a break now, you can let me know. I'm going to continue. At the time of the preliminary examination, the burden is on the prosecution to establish probable cause, and they have to establish probable cause that a crime was committed, and that there's sufficient probable cause to charge you, the defendant, with the crime. And so the burden, as stated by your attorney, is relatively low. It's more evidence than just mere suspicion that a crime was committed, but it's certainly not as much evidence that would be necessary if this matter were to proceed to a trial, because at that time it would be beyond a reasonable doubt, which is a much larger burden. Today we heard some testimony today from an alleged victim, Jaleesa Hernandez. She testified about altercation that took place, at least electronically via Facebook Messenger, I believe she said, on September 29, 2021. She indicates or identified the defendant, Ms. Cerise Coach Merchant, as the defendant or the subject in which she was arguing with, and that there was a message or phone call from the defendant stating that she was going to be pulling up to the alleged victim's house and wanted to fight. The witness or victim also testified that there were phone calls from the defendant to the victim, threatening to go to the victim's property and cause some vandalization to her home. Victim calls the police. Victim was at urgent care at the time. She leaves urgent care to go back to the house to check on it, finds that the threat of vandalization was not viable, so she then calls off the police. She goes, then she says, to the dollar store. On her way home, she testified to seeing the defendant in a red Equinox, which she identified as a vehicle that she was familiar with the defendant owning, and that as the defendant drove, that also she testified that she was in the passenger seat and not the driver, as they were stopped at a stop sign at the intersection of Bailey and Sheffield, that as the defendant was driving past, and her window was halfway down, and that was when shots were fired at the victim's vehicle. She testified to there being 7 shots fired, or approximately 7 shots fired. 5, I believe, shots hitting the vehicle, 1 going through the back seat. She testified she was unable to see the exact location where the shots was being fired from, She also testified that she did not see the defendant with a firearm, and then she also testified that she doesn't know the defendant to possess or own that firearm. He had testimony then of the detective trooper John Brady, who testified that he investigated the scene and he recovered some casings. He had an interview with the defendant, and it sounds like there was more than one interview, but the first interview with the defendant was in contradiction to the second interview. First interview, the defendant initially denied that she was at the scene. Then she later said that she was at the scene of the incident and heard the shots, but that it came from a separate vehicle. And she provided the name of someone by the name of Trey, who turned out to be the victim's ex-boyfriend. Also provided information of a cousin that was supposedly in the vehicle with the defendant, but that name was determined to be a person that did not exist. There was a second interview with the detective in which is where the information, I believe, that provides sufficient factual evidence is where the defendant places herself at the scene. She also indicates that she was present when the shooting occurred. Again, there's been no testimony and there's been no evidence provided that would allow this court to believe that the defendant herself did some shooting, but there was testimony from the officer that through his investigation and through statements made by the defendant to the investigator that she had admitted to going to the scene and that she had contacted and set up to have other individuals accompany her to the scene. Most importantly, there was text messages that was recovered from the defendant sending, saying, you know, I'm going to kill you, right? And that was sent prior to the shooting. And that the defendant admitted to sending that text message to the alleged victim. And so the prosecution is requesting the court to bind over as to count 1 or count 2 on the theory of aiding and abetting or accessory after the fact. I believe that there is sufficient probable cause based on the statements and testimony of the officer of the alleged of the defendant that she sent a text message. She said, I'm about to kill you. That there is obviously testimony from the defendant or from the victim. Strike that. There's obviously testimony by the detective that the defendant stated to him that she was at the scene and that she was present during the shooting, so she's placing herself there, and that shell casings and shots were fired, that the victim's car did sustain injury. I think that because of that text message, we have sufficient probable cause as to count 1 assault with intent to murder, and that the court will bind over under the theory of aiding and abetting, because I believe that based on the information provided by the detective, that the defendant told him that she had went to the victim's house and brought other individuals into the house, but also that she admitted that the situation was not supposed to go as far as it did. I believe that there's sufficient probable cause to believe that she orchestrated this incident. And so the court will bind over as to count 1 assault with intent to murder under the theory of aiding and abetting. Count 3 will be dismissed. Count 4 will be dismissed. Count 5 is a weapons firearm discharge from a vehicle. and that will also be bound over under the theory of aiding and abetting. The bind over date is going to be February 23rd. You do not need to appear in court on that date. That's just the date that they'll get the file from this court. Once they get the file, they'll set your next court date. It'll be a pre-trial in circuit court. Your attorney will be made aware of what your next court date will be. You stay in contact with your attorney, okay, ma'am?
Your Honor, if I may.
You know,
To clarify, I did hear that count 1 and count 5, but with regards to count 2, is that being bound over in the alternative as well, or is that being?
I'm dismissing count 2. I'm binding over on count 1.
Okay, thank you.
The bond was set at 25,000 cash surety. That will continue. As well as the no contact order as to Ms. Hernandez, but because the remaining counts against DeMarcus Salam is going to be dismissed, that no contact order as to him will be amended. Any additional matters for the record?
Nothing further from the people.
Nothing further, Your Honor. Thank you.
Thank you. You're all set.
Thank you, Judge.
Thank you.
No, you're fine. I need to stay inside. You can, or.
Okay, on the record in the matter of the people of the state of Michigan versus Amanchi Clay, by number 22-00218, FY council appearance.
Good afternoon, Your Honor. Andrew Lacy is hearing on behalf of people.
Charles Trowbridge on behalf of Mr. Clay, who's present to my right.
So there was a date set for the preliminary examination on this file. Are we ready to proceed on this?
Yes, Your Honor.
Yes, the defense is ready to proceed. One preliminary matter, similarly to Mr. Palmer's case earlier, I would ask that Mr. Clay's right hand be freed so he's able to review discovery.
Absolutely, that can be granted. Okay, any other preliminary matters?
Nothing from the people, sorry.
No problem.
And no further matters from the defense. Thank you.
Before you go to this.
Thank you. For the first witness, the people called to the stand, Officer Troy Mangrum.
Right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
You can have a seat there. Can you please state your first and your last name and spell them both?
First name is Troy, last name is Mangrum, TroyMangrum.
Thank you. Continue to proceed.
Thank you. Officer Mangrum, can you please tell me what your occupation is?
Police officer, City of Lansing,
And how long have you worked for Clancy?
5.5.
Did you work as an officer prior to that?
No, ma'am.
Officer Mangrum, I'm gonna take you back to January 22nd of 2022. Do you remember that date?
Yes, ma'am.
And were you working in your capacity as a police officer on that date?
Yes, ma'am.
Were you working for Lansing PD on that date?
Yes, ma'am.
Okay. Were you working alone or with a partner?
He's with a partner,
Okay, and what is your partner's name?
Officer Jake Ellis.
Thank you. What kind of vehicle were you in on that date?
Ford Explorer,
Was it a fully marked car or an undercover vehicle?
fully marked.
And how were you dressed?
I was in full uniform.
And on that date, did you have the occasion to be present in the area of 1321 North Martin Luther King in the city of Lansing, county of Ingham?
Yes, ma'am.
Okay, and is there anything located at that address or it's just an intersection?
Just an intersection.
And can you tell me what it is that prompted you to go to that location?
I was dispatched for a motor vehicle accident for hit and run.
Okay. And what happened when you arrived on scene?
When I arrived on scene, there was other officers that were present on scene before I got there. Started doing scene management. I worked with fellow officers there, and we got dispatched over the air that they had potentially located the subject that they were looking for. So I got back in the vehicle with my partner, and we went to the secondary location.
Okay, let me ask you, if you remember, what officers were present when you arrived on scene?
Officer Hayden Erickson,
Okay,
and I don't recall the other officer that was there with Hayden.
but do you recall it was one or just one other officer?
I believe it was just Hayden. that was
Okay.
there.
Thank you. And where was the second scene? You said?
Was Theodore and Martin Luther King Boulevard.
Okay, and what was going on over at Theodore and Martin Luther King?
Officer Hayden had pulled a traffic stop on a vehicle, and a passenger had exited the vehicle from the traffic stop, running eastbound on Theodore towards Martin Luther King.
Okay, and Theodore and Martin Luther King, that's still in the city of Lansing, county of Bingham?
Yes, ma'am.
Okay, and what did you do at that point when you had learned about the passenger who had fled?
Saw an individual matching the description running on Theodore towards Martin Luther King. I exited the vehicle. At that point, my partner Jake, who was driving, lit up our emergency lights. I jumped out of the vehicle, gave verbal commands to the subject to stop because I was the police. So I said, "Stop, police," and then put chase ensued after that.
Okay. So, you said you saw somebody matching the description, and where did that description come from?
Dispatch.
Dispatch.
Yes, ma'am.
And okay. Now the person that you were pursuing, is that person present in the courtroom today?
Yes, ma'am.
Can you please point to that person and describe what they're wearing?
It's this gentleman here. He was wearing all black.
Your Honor, please let the record reflect that the witness has identified the defendant.
Is there any objection?
I would just clarify, are you saying he's wearing all black, or is it the blue jumpsuit today, or are you referring to the clothing on the night in question?
Clothing on the night in question, sir.
So what is he wearing today?
Blue jumpsuit, sir.
Then I would have no objection for the purpose of the.
Thank you, okay.
I apologize, Your Honor. I totally went over my head.
No worries, but plus it's not good lighting in here, so,
It could easily be black.
exactly, so identification has been noted.
Thank you. Okay, and at that point, what did you do after you had given those verbal commands for him to stop?
As I mentioned, a foot chase had ensued at that point. Officer Ellis and myself had chased the subject south on Martin Luther King. My partner, Jake, had subdued the individual, brought him to the ground. And that's when I met up with Jake on the ground with him to put the individual in handcuffs to secure him.
Okay, and what happened at that point?
I grabbed the individual's left arm, got it behind his back. Officer Chang showed up shortly thereafter to help subdue him with us. We got his right arm behind his back, and we got him in cuffs.
Okay. Once he was taken into custody, did you have any further contact with the defendant?
After he was in cuffs, Officer Chang and myself walked the individual to Officer Chang's patrol vehicle and put him in the back of the vehicle.
Okay.
And that was the last time I had contact.
Okay. And did you return to the original scene at 1321 Martin Luther King?
Yes, ma'am.
Okay. And what did you do once you returned to that scene?
I did an inventory search on the vehicle. It was in question for the hit and run.
Okay.
Officer Hayden was there doing the inventory, and I took over for him.
Okay, so it was started by Officer Hayden, but you finished it?
Yes, ma'am.
Okay. And as a part of that search, was there anyone else in the vehicle besides the defendant at the time of the incident or the crash? I'm sorry.
I showed up after the incident had occurred, so when I was there, no, I didn't see any individuals at all in the vehicle.
Okay, and you didn't have any knowledge that there had been anyone else alleged to have been in that vehicle, is that correct?
No, ma'am.
Okay. Now, while you're doing the search, were you able to locate anything?
Yes, ma'am. I located multiple items of paraphernalia.
Okay, I'm gonna make you dumb it down for me. Paraphernalia, what do you mean when you say that?
So within the vehicle, I located a black and red zipper style case that had 2 scales. And then within that case, there was a secondary compartment that was also a zipper style compartment that had multiple small red baggies.
And Your Honor, please let the record reflect that I am showing what has been marked as people's proposed exhibits 1 and 2 to defense attorney, or to defense counsel. I approached the witness, Your Honor. Thank you.
Yes, ma'am.
Okay, Officer Mangrum, without telling me what's in those pictures, do you recognize those photos?
Yes, ma'am.
How do you recognize them?
These are the items I pulled from the vehicle.
Okay, and did you take those photos as well?
Yes, ma'am.
Okay, and were those taken on scene or off, or away from the scene?
Away from the scene.
Okay, but you would indicate that what's included in those photos was the items that you found at the scene, is that correct?
Yes, ma'am.
And they are depicted in the manner that you observed them in the vehicle?
Yes, ma'am.
Okay, so they're a fair and accurate depiction of those items.
Yes, ma'am.
Okay. Your Honor, at this time, I would ask that they be admitted as people's proposed, or people's exhibits 1 and 2.
Any objection?
No objection for the three that are on.
Exhibit 1 and 2 are admitted.
Officer Mangrum, can you just briefly tell us what is pictured in exhibit number 1?
Exhibit 1 is the black zip-up case that I was able to locate within the vehicle that had the 2 scales and multiple red baggies located within it.
Are the scales also depicted in that picture?
Yes, ma'am.
And what is in exhibit number 2?
Exhibit number 2 obviously has what is exhibit 1, which is that red zip-up case. In addition, there's a card, that multiple colored card that's in there with that small white rock that was discovered inside of that folded up card. A Smith & Wesson 40 caliber handgun magazine that was unloaded, and a syringe that had a brown substance in it.
Okay, thank you. Your Honor, may I publish for the court?
Yes, please.
Okay. Now, Officer Mangrum, based on your training and experience as officer, does the scale of the baggies indicate anything to you?
Based on my training and experience thus far, they were generally used for drug paraphernalia and or distribution.
No, I have no further questions for Officer Mangrum.
Thank you. Cross-examination.
Yes, sir. Good afternoon, Officer Mangrum.
Afternoon, sir.
Just to be clear, you arrived after the fact of the accident, is that right?
Yes, sir.
And your pursuit of the suspect in this case was based solely on what you were hearing from other officers?
Yes, sir.
And so that caused your pursuit, but you didn't witness any underlying facts that would have caused the need to pursue.
Correct.
And you just described the items based off your training experience as an officer as indicating paraphernalia. I wasn't quite sure if you said paraphernalia for distribution or paraphernalia for distribution.
Paraphernalia and or distribution.
So it may be an indication of drug use as well as potential distribution. Is that your position?
Potentially, yes, sir.
And there's often other things based off your training experience that indicate there are other types of evidence that may indicate distribution. Is that correct?
Yes, sir.
That would often be large amounts of cash and various bills, or perhaps several different cell phones. Is that often what is associated with that?
Yes, sir.
Did you find any of those other indicators?
I did not recover that, no, sir.
And just to clarify on the arrival, it was, you initially believed there were 2, but just to be absolutely clear, it was only Officer Erickson when you arrived on the scene.
To the best of my recollection, yes, sir.
And he was he already doing the inventory search on your initial arrival?
Yes, sir.
And you took over for that after the checks, is that right?
Yes, sir.
you have no further questions. Thank you.
Thank you. Trying to see if we have any questions. I think he said, in these pictures, one of them was supposed to show a small white rock. Is that supposed to be on this one?
Yes, ma'am, it's in the multicolored card there.
Okay, okay. And this witness didn't provide any testimony as to what that rock was, did he?
No, he did not.
Okay. Any redirect?
No redirect.
Okay, thank you, Officer Mangan, you can be excused.
Thank you.
Call your next witness.
Thank you, Your Honor. For the people's next witness, we called to the stand Officer Sharon Chang.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Think you can have a seat there, officer? Can you please state your first and your last name and spell them both?
My first name is Feiran, Feiran. My last name is Cheng, Cheng.
Thank you. You can proceed, counsel.
Thank you. Officer Chang, can you tell us what your occupation is?
I'm a police officer with Lansing Police Department.
Okay. And how long have you worked for the Lansing Police Department?
About a year and 2 months.
I'm going to take you back to January 22nd, 2022. Do you remember that date?
Yes.
And on that date, were you working in your capacity as a police officer?
Yes.
And were you working for Lansing PD on that date?
Yes.
Were you working alone or with a partner? Do you remember?
I was working with a partner,
What's your partner's name?
Daniel Salinas, Officer Daniel Salinas.
Sorry, I'm trying to find a spelling for the record, but I don't. I believe it's Falinaz. And can you tell me what kind of vehicle you were in that day?
I was in a fully marked patrol car.
Okay. And how were you dressed?
I was in a fully dressed LPD uniform, patrol uniform.
Okay. On that date, did you have the occasion to be present in the area of 1321 North Martin Luther King in the city of Lansing, County of Ingham?
Yes.
And if there's anything there, what's located at that address?
It's a Family Dollar store.
Okay. And what prompted you to go to that location?
I heard the other officers call out on the radio. Initially, it was a property damage accident.
Okay.
And foot pursuit was initiated.
And did you join in that pursuit?
I responded to that area and hoping to do my best to assist the officers on scene, and I was able to assist.
Okay. And what happened when you arrived on scene?
When I arrived on scene, I saw the accused was already being placed on the ground.
Okay.
So I exited my patrol car and assist the officers on scene with the securing him in handcuffs.
Okay. And as part of that, what did you do?
I then conduct a search incident to arrest.
And as a result of the search incident to arrest, did you find anything on defendant's person?
Yes, I found a green container with white powdery substance, which I believe to be a controlled narcotic.
Was there anything else in this green container?
Clear baggies with white powder stuff.
Okay. And where was this located?
I remember it was in his left front hand pocket.
Your Honor, please let the record reflect, I am showing what has been marked as people's proposed exhibit 3, 4, 5, 6, and 7 to defense counsel. Permission to approach, Your Honor?
Yes.
Officer Chang, without telling us what's in those photos, do you recognize those photos?
Yes.
Okay, and how do you recognize those photos?
By the items that was displayed in the picture.
Okay, and did you take those photos?
I did not.
Okay, but would you say that they are a fair and accurate depiction of what you found in Mr. Clay's left hand pocket?
Yes.
And everything that you found in his pocket is included in those photos, is that correct?
There was a key fob as well that was not included in this picture.
Okay. Thank you. But everything else that you found is included, is that correct?
Yes.
Okay. Now, Your Honor, I would ask that people's proposed exhibits 3, 4, 5, 6, and 7 all be admitted as people's exhibits 3, 4, 5, 6, and 7.
Any objections?
Not for the field, Your Honor.
Admitted. 3, 4, 5, 6, and 7 without objection.
Thank you. Officer Chang, can you please go through the pictures and tell us what's included in each? We'll start with exhibit number 3.
In this picture, there was a green metal container, and those plastic baggies was located inside of a green container,
Okay.
and as well as a black round shape container.
Was that also located inside that green container?
It was a separate item located in his pocket.
Okay, same left front pocket though?
That's correct.
Okay. What is depicted in exhibit number 4?
It was one of the plastic baggies that was located in the green container.
Okay, and number 5.
There was an additional clear plastic baggie located inside of a green container.
Okay. And exhibit number 6.
One more additional clear plastic baggie located within the green metal container.
Oh, and lastly, exhibit number 7.
It's a black round shaped container that was located separate with green container.
Thank you. Your Honor, permission to publish for the court.
Yes.
Thank you. Officer Chang, you indicated there was a white powdery substance included in each of those items, is that correct?
Sorry?
Did you indicate there was a white powdery substance?
Yes.
Was it in the container in each individual bag and container that was found in his pocket?
Yes.
Okay, and did you do any testing of that powder?
I did not.
Okay. Do you know if testing was done of that powder?
I'm sorry?
Did you know if anybody tested that powder?
Yes, Officer Jake Ellis.
Did you have any other contact with Mr. Clay?
Yes, I transported him to Sparrow Hospital where he got medical care.
Okay, and the person whose pocket you pulled those items from is present in the courtroom, is that correct?
Yes.
Can you please point to that person and describe an article that they're wearing for the court? Or an item that they're wearing for the court?
He was wearing a dark blue shirt with a long sleeve on the shirt.
Thank you, Your Honor. Please let the record reflect the witness that identified the defendant.
No objection for the freedom.
And you indicated you did have more contact. Where did you take him again? I'm sorry.
To Sparrow Hospital.
Okay. And once he was at Sparrow Hospital, did you stay with him or did you?
I stayed with him.
Okay. You didn't. Did you interview him with regards to the stuff that you found in his pocket?
I did not.
Okay. Thank you. No further questions, Your Honor.
Yes, Your Honor. Good afternoon, Officer Chang.
Sir.
So just to clarify what's in the pictures, and I know they've been published to the court, but none of the baggies located in the green container were similar, is that correct? They weren't the same bag or multiple of those bags?
There were several, they're plastic baggies.
Yes. It appears that one of them has a zip top, one appears to be a portion of a shopping bag, and then one appears to perhaps a different style of zip top. Is that fair to say?
Yes.
So they're three different types, but similar bags.
Yes.
And you indicated you've been working for LPD for about 14 months?
Yes.
And in that occasion, have you had the experience to arrest individuals who are users of controlled substances other than this situation?
Yes.
And for individuals who are using, do they often, or do they only ever have one bag of drugs on them?
It varies by person.
So for general users not dealing, it's common to see people with multiple amounts of drugs on them, small amounts.
Can you repeat your question, please?
Based on your training experience as an officer, is it common for people who are solely suspected of being drug users to have multiple small amounts of drugs on them?
On different patients, yes.
And your sole interaction was between the time when you saw him arrested, performing the search incident to arrest and transporting him to Sparrow. Is that right?
Yes.
You did not witness any car accident or see Mr. Clay in any vehicle?
I did.
Thank you. I have no further questions.
No.
Thank you. You may be excused, officer. Officer Chang, can you call your next witness?
For our next witness, Your Honor, we will call to the stand Officer Jake Ellis.
Thank you. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can have a seat, your officer. And can you please state your first and your last name and spell both of them?
Jake Ellis, JakeEllis.
Proceed, counsel.
Thank you. Can you please state your occupation for the record?
Officer of the Lance Police Department.
How long have you been employed by Lansing Police?
Just under 3 years.
Officer Ellis, I'm going to take you back to January 22nd, 2022. Were you working in your capacity as a police officer on that date?
Yes.
Were you working for Lansing PD on that date?
Yes.
And do you remember, were you working alone or with a partner?
I had a part of that.
What was your partner's
I
name?
was Officer Mangrum
And a vehicle were you guys in?
in a fully marked patrol car.
And what kind of clothing were you wearing?
Our fully marked Lansing Police uniform.
Okay. On that date, did you have the occasion to be present in the area of 1321 North Martin Luther King in the city of Lansing in Ingham County?
Yes.
And is there anything at that address?
That's a residence.
And what prompted you to go to that location?
We were responding to initially a PD accident, then it turned into a hit and run with a driver when the DQ vehicle clean on foot.
Okay. What happened when you arrived in that location?
We initially looked for the cues, which is described as a white male wearing all dark or black clothing. Initially couldn't find them. Eventually, Officer Erickson was able to locate them near the Family Dollar at King Willow.
Okay, and what happened when you heard about that?
We responded back to the immediate area, and eventually, after officers attempted to stop the vehicle, somebody jumped into. We jumped back out, and they were calling out the direction he was going.
Okay, so he indicated that officers were attempting to stop a vehicle that he had gotten into. Were you the officers that were attempting that traffic stop?
No.
Do you know who was?
Officer Erickson and Officer Kurtz.
What is the other name? Erickson and who?
Kurtz.
All right. And where were you when you saw this taking place?
I was at King Willow.
Okay, and how far away is that?
From the spot that they initially the traffic stop?
Yeah.
It's about 1 block to the east.
Okay. And were you able to see the person you described as the suspect get out of that vehicle?
No.
Okay. What did you do at that time when you heard about the traffic stop?
I responded to the area after Officer Kurtz stated that the subject was now running eastbound on Theodore. I drove south on King to the next intersection, which would be King and Theodore, and saw the subject running up to that intersection.
Okay. And what did you do at that point?
Jumped out of my patrol car, gave the command for police stop, and he ran southbound King. And I pursued.
Okay. Yeah. What happened when you were pursuing that person?
We ran south to the intersection of King and Glen. The exact address is in my mind. It was a front yard in the northeast corner of the intersection. He attempted initially to stop, he turned, but with the momentum I had and with the conditions being snowy and icy, I couldn't stop him at that point.
Okay.
Taken to pursuit.
And is that person that you were pursuing and tackled and took into custody, is that person present in the courtroom?
Yes.
Can you please point to that person and describe what they're wearing for the court?
He's got the Eaton County blue jumpsuit on.
Thank you, Your Honor. Please let the record reflect that the witness has identified the defendant.
No objection for freedom.
Identification is known.
What happened after you were able to handcuff the suspect?
I initially got off, and then the other officers that assisted began to stand off.
Okay.
And he proceeded to have a seizure.
Okay, so you're saying he had a seizure at that point?
Yes.
Did medics arrive on scene?
No.
Okay.
After the fact.
Okay. Was he taken into custody and transported a different way?
Yes, in a patrol car.
Okay. Do you know whose patrol car by chance?
Officer Chang.
Okay. What did you do at that point?
At that point, Officer Mangrum and I went back to the initial scene at 13 Point North King. He helped Officer Erickson search the vehicle.
What did you do?
I survived supervised and he's in that jail.
What is that?
He's a recruit with field training.
Okay.
So I was helping the supervisor.
Okay. And what happened after that?
Officer Mangrum was able to locate drug paraphernalia,
including scales and small baggies, along with some suspected narcotics.
Okay, and did you see those items while you were on scene?
Yes.
Okay, and based on your training and experience as an officer, does the scales and the baggies indicate trafficking too?
Yes.
And then what did you do after that?
We took the evidence. Actually, initially, we went to Sparrow Hospital and met up with Officer Chains. His partner, Officer Simmons, that night. So chain of custody of their evidence and tag it all in together. We took it downtown to get it tested with true narc and tag it.
And did you perform the true narc on those narcotics?
Yes.
Okay. And Your Honor, please let the record reflect, I am showing what has been marked as People's Proposed Exhibits 8, 9, 10, 12, 13, and 14 to defense. You may approach, Your Honor. You may. Dr. Ellis, without telling us what's in those photos, did you recognize those?
Yes.
Okay, and how do you recognize them?
Through the evidence that we see and tested.
And did you take those photographs?
Officer Mangum did.
Officer Mangum did? Were you present when you took those photographs?
Yes.
Okay. And would you indicate that those photos are indicative of what the evidence looks like on the night that you did the testing and after you found them?
Yes.
Your Honor, I would ask that People's Proposed Exhibits 8, 9, 10, 12, 13, and 14 be entered into evidence as People's Exhibits 8, 9, 10, 12, 13, 14.
No objections are free, Your Honor.
Okay, people exhibit 8, 9, 10, 12, 13, 14 are admitted.
There's no 11.
Thank you.
Officer Ellis, if you could, you'll have to help me if I'm wrong with the numbers, but can you please describe for the court what is shown by exhibit number 8?
Number 8 is a plastic baggie with suspected narcotics inside, which with the true narc test would be positive.
Okay, and can you tell me what is depicted by exhibit number 12?
That same baggie that we tested suspected narcotics on the scale in our quartermaster.
And what is the weight of the narcotics?
1.5 grams.
1.5 grams?
Yes.
Okay. And then can you tell the court what is depicted in exhibit 9?
Number 9 is another baggie of methamphetamine, suspected methamphetamines that we located, and it did indeed test positive for methamphetamines.
Okay, and can you tell the court what is depicted in exhibit number 13?
That same baggie on the same scale that we used to measure the first evidence.
And what is the weight of that narcotic?
It is 2.5 grams.
And can you tell the court what is in exhibit number 10?
Is another baggie of methamphetamines that we tested with the black container that it was initially located in.
Okay, and did that test positive for methamphetamine?
Yes.
And can you tell me what is in exhibit number 14?
The baggie on that scale with gram or the weight of 1.5 grams.
You're gonna publish to the court. Officer Ellis, if you know, do you know how much methamphetamine is consumed by one person for one use?
I'm not.
Based on the packaging, based on the evidence that was found on Mr. Clay's person, and your training experience as an officer, does that indicate trafficking to you as well?
Yes.
No further questions, Your Honor.
Yes, Your Honor. Good afternoon, officer.
Good afternoon.
Looking at the exhibits and all the amounts weighed, they include the baggie on the scale, is that correct?
Yes.
Did you ever weigh the baggie independently of the suspected or tested narcotics?
No, we included the weights with the packaging. The original packaging was located with them.
So
Besides one of the items.
I'm sorry, could you repeat that?
One of the items is that black container, but the laser and the true narc would burn that black, so we had to go with that piece of plastic for testing, for proper testing.
But just to be clear, the weights represented in there are, it's not specifically 1.5 grams of methamphetamine or suspected methamphetamine. It's 1.5 grams combined between methamphetamine and package.
Yes.
And you just indicated at the end there that based off your training and experience that this indicated trafficking.
Yes.
Could you define trafficking or your definition of trafficking for that?
Exact definition or for this circumstance?
For what you just intended to convey in your testimony?
Well, with the numerous scales we found, the small red plastic baggies, the way the methamphetamine is located were in small different plastic baggies. My training experience, that's what subs usually use to deliver that narcotics. When the narcotics we take from that smaller, the plastic bags they were in, the small red little dime bags, and those be delivered to their for.
And you indicated in response to Ms. Lacy's question that the amounts found indicated trafficking. Is there anything about those amounts? What is that a general amount that could be just how many doses do you think that was allowed to?
I'm dealing with other methamphetamine users. Takes one small rod for personal use, so that methamphetamine could be distributed to numerous people possibly.
So it could be.
Could be.
And you never saw Mr. Clay in the vehicle that was crashed, is that right?
That's correct.
If there were not the items in the vehicle, there were solely the items located on this person, the items weighed. Does that, without more, indicate trafficking to you?
No, the items in the vehicle were important.
Were you aware of all the items taken out of the vehicle?
Yes.
And in there, there was a loaded syringe?
Yes.
Do people distribute loaded syringes in your training experience?
Yes.
They distribute them loaded, not for personal use?
That is correct.
Is that syringe capped?
I don't recall.
Right, I have no further questions.
Thank you. Is there any redirect?
Just briefly, Your Honor, Officer Ellis, you had indicated that you were looking for a suspect based on a call out. Were you made aware that there were multiple people in this original motor vehicle accident?
Just one person.
Okay. And based on the call out that you heard,
Objection. I've not been objecting to the basic hearsay things coming from the other officers. I believe that falls into the hearsay exception for effect on listener, not for truth of the matter asserted. I think at this point we're approaching hearsay as truth of the matter asserted.
You want to respond?
And I was gonna ask if he was aware that there were other suspects also being sought out in the same area.
Well, we have an objection, so you can't give a response. Are you withdrawing your objection or are you continuing it based on that question?
I would continue it at this point because I believe that as far as the pursuit following that, the search incident to arrest, the arrest itself being legally potentially justified here, I think all of that goes to the effect on this. Whereas here, there was no actual effect or reaction to the fact that there were no other individuals, that's the question proposes, involved in this. So I believe that it does still fall outside of that.
I'm gonna sustain the objection. That answer is stricken. You can continue.
Thank you. I have no further questions.
Thank you. Officer, you can be excused. Do you have any other witnesses?
No, Your Honor.
The defense calling any witnesses?
No proofs today, Your Honor.
Okay, thank you. You can proceed to argument.
Your Honor, we have had testimony today that there was some type of accident wherein the officers were searching out an individual in the area of Martin Luther King. The officers were able to locate that person. An arrest was effected. A search of this person was also effected. During that search, there were numerous baggies found inside of a green container, along with a separate black container in his left front pants pocket. The officers did retrieve those items. They were able to test them, at least true narc them, and all of those baggies located in the pocket, as well as the container, tested positive for methamphetamine. The total weight does include the baggies, as well as the narcotics. The total weight here is 5.5 grams. In addition, Your Honor, the vehicle that the defendant was seen in and fled from was searched originally by an Officer Hayden, who's not present today, but the search was continued by Officer Mangrum. He did indicate that in that vehicle there was 2 scales as well as numerous small red baggies found in the vehicle, along with other paraphernalia, a syringe, another card with suspected narcotics, and some other things. I know there's a key fob in a pocket. I forget what else is in the vehicle. An unloaded magazine, I believe. The officers have indicated that each one of them, I believe, based on their training and experience as an officer, all of those things taken together indicate trafficking. The way that the individual packages of methamphetamine that were found on the defendant's person could be broken down and distributed by being placed into those bags. I believe the officer called them dime bags, and distributed to other individuals. Further, Your Honor, the officer had also testified that based on his experience and training, that even a loaded syringe can be distributed to another person, and all thus would constitute trafficking. I would argue that based on the totality of the evidence found, that there is more than sufficient probable cause to bind the defendant over on count 1, possession with intent to distribute methamphetamine. Obviously, count 2 is misdemeanor while follows the circuit court. I would ask that you bind over as such. Thank you.
Your Honor, I would ask that the court decline to bind over on the possession with intent to distribute. In this circumstances, I think may have been indicated by my last objection there. All indications that my client were actually associated with the car were something where we did not hear any actual under oath testimony today regarding that. Actually seeing him in the vehicle, leaving the vehicle. We do know that for the purposes of the other officers, the officers we've heard from today pursuing and ultimately arresting Mr. Clay, I do know that effectively my understanding of precedents is that as long as there is some reliable source of information, such as dispatch, such as other things, that justifies the behavior. However, that is not itself evidence of that. It does not prove that he was ever actually in the vehicle and does not actually militate towards that, as it is indication of their justification for the arrest. Taken that, I do not think that the people had met their burden of proof to associate Mr. Clay with the contents and what was found solely within the vehicle. So I believe that this should only be analyzed on the materials that Officer Chang took directly off of Mr. Clay, which all three officers, in their opinion, indicated that it could be personal use. Some indicated it could be personal use or distribution. The officer who came closest to that was Officer Ellis at the end, who in his testimony stated two things that were directly contradictory. He does not know how much someone uses as a dose, and of course you can spread that out to several doses. He doesn't know the amount of the dose. He doesn't know that that could actually be distributed. And that itself relied on the existence of scales and the baggies found in the car, which again, I believe are not something that the people have proven that there is an actual admissible evidence to demonstrate that Mr. Clay was actually associated with that vehicle as was found in search warrant. So I'd ask the court to decline to bind over on count one as the only evidence that actually directly tied to Mr. Clay is indication of simple possession without intent to distribute.
Thank you. Okay, and Mr. Clay, again, today is the day that was scheduled for preliminary examination. The burden today is on the prosecution. They have to establish sufficient probable cause that a crime was committed and probable cause to charge you with the crime. The burden of probable cause is a relatively low burden that requires more than just mere suspicion that a crime was committed, but not nearly as much evidence that would be needed to meet their burden if this matter was to go to trial, which is then beyond a reasonable doubt. Their testimony today from Officer Jake Ellis testified that he was dispatched on the date of January 22nd, 2022 at 1321 North MLK, Lansing, Ingham County, in regards to a hit and run for a motor vehicle or property damage accident, and that there was another officer that was present at the scene. He testified that the passenger, or the driver of the vehicle, I should say, the driver of the vehicle, or that he was told by Officer Hayden that through dispatch, that the driver of the vehicle was stopped and that he fled. Officer Ellis said he saw the individual matching the description given by the other officers, and that he and his partner began to subdue the suspect. He eventually was taken into custody. He returned to the scene of the property damage incident and performed inventory search of the vehicle. He did testify that he had no knowledge that anyone else had been in the vehicle. This search recovered multiple items, including what he had termed as junk paraphernalia, but 2 scales and some small red baggies. And a small white rock was discovered inside of a folded up piece of colored paper. There was a Smith & Wesson unloaded magazine and a syringe. We had Officer Chang testified that he heard a radio traffic about property damage accident and a pursuit that was initiated, and that he reported to the area of the incident. At the time that he reported it, he was already in custody. He was on the ground. He conducted a search into the grass he found on the person of the defendant, a green container with white powder substance and some baggies that was located in his pocket. We also heard testimony of Officer Jake Ellis. Again, he discusses radio traffic about a property damage incident, a pursuit of the defendant, who was later taken into custody. He was the one who attested the suspect or the suspected narcotics that was located on the defendant, which did come back as testing positive for methamphetamine. The defense is arguing that because the scales and the small red baggies, I guess, is the paraphernalia is being described as, because those were found in the vehicle and not on the defendant, that is insufficient evidence presented to tie the defendant to the vehicle. But there's been countless testimony today of the radio traffic of officers and officers who had pursued the defendant after seeing him in a vehicle that had been involved in a property damage accident and fleeing the scene, and then he later fled on foot. I think that that's sufficient probable cause to believe that the defendant is the person and the sole occupant that was in the vehicle. There was no testimony provided that there was anyone else associated with that vehicle. So the court is satisfied that there is sufficient evidence to a probable cause standard to bind over and count one controlled substance delivery, manufacturing, and methamphetamine. Count two, a failure to stop after a collision, it's going to be bound over with it. That's a misdemeanor, and I'll accompany this to the circuit court. Bind over date's going to be February 23rd. Time to be determined by the circuit court. You do not need to appear in court on that date. That's the date they're getting the file from this court. They'll set your next court date on this file, and Mr. Petrovich, your attorney on this file, will be made aware of that next court date. You have already been arraigned on the other files. Is that correct?
Yes, ma'am.
Do you have any questions for the court today, sir? Okay. Is there any additional matters for the record, counsel?
Nothing from the people.
Since your honor already expressed your opinion on the bond motion there.
Here are your exhibits.
Thank you.
No problem.